just don't mess around with. I see him passing by with his top hat on and his purple coat of velvet. My taser salesman is the kind of guy, he gets so excited when they call him in to testify. He says, yeah, I'm invited to show and tell all about the tasers that I sell in court. He's proud to give the word, he's happy as a songbird. My taser salesman has got all the toys, he's a big-time vendor. If you want a high-voltage device, he's the guy you should surrender to. The next time I got pulled over, the cop said out of the car, I said before you pull out your taser, you should talk to my lawyer who can show and tell all about the tasers that he sells in court. He's proud to give the word, he's happy as a songbird. The next time I got pulled over, the cop said out of the car, I said before you pull out your taser, you should talk to my lawyer who can show and tell all about the tasers that he sells in court. He's proud to give the word, he's happy as a songbird.
Oh wait, here we go. I like that song. That's the taser salesman song. That's awesome.
Yeah, I've never seen a happy guy more excited in the court testifying about what he sells.
I gotta be on the Swedish side. Yeah, no, that's that guy. He was so freaking happy to be there and talk about tasers. The guy was amazing. Good morning, Nick. Good morning, chat. Welcome everybody to another dual stream, MLS and Nick Staroff Trial Watch for day 4 of the Christopher Schurr trial. We learned some interesting news this morning that apparently the defense has 40 witnesses on its list. So we thought we were going to be like wrapping this up. We're like, oh, they can't have that many witnesses. Apparently there's 40 witnesses. Now, I don't know if they're going to call them all, but we'll see how today goes. I was thinking they might call, they're going to finish up the cross-examination of the captain. There'll probably be some redirect, maybe another witness, and then we'll get to the defendant, if he testifies. That's what I was anticipating. But to learn that there's 40 witnesses, this might go 2 weeks.
Yeah, I must say I was really surprised because I'm not entirely sure what all these witnesses will talk about.
That's my question. What are they going to talk about, right? So to recap, what we have is an officer-involved shooting. The officer initiated a traffic stop lawfully because the plate on the vehicle did not match the vehicle itself. The defendant, or the not the defendant, the Lyoya, got out of the vehicle immediately. We don't know why. There's been, suggestions that he was checking on his vehicle because it was making noise, but the officer doesn't know that. He gives Lyoya a command to get into his vehicle. Lyoya does not get back into his vehicle. The officer asks for his identification. He's unable to produce identification. When the officer goes to detain him, then Lyoya pushes the officer off, struggles with the officer, then takes off running. The officer then gives foot chase past the front bumper of his car, which apparently is a bad thing. Tackles him in the lawn right next to where the vehicle is. Tries to get him to compel, keeps giving him commands to put his hands behind his back. Eventually draws the taser after chasing him to the other side of the yard. And then Lyoya grabs the taser. They struggle for the taser for about 2.5 minutes. I think the taser struggle is. Lyoya gets full control of the taser. It's under his body. Lyoya is face down on his stomach, or sort of on his stomach, on his knees. It's not really clear. While Christopher Schurr is on Lyoya's back. And then Christopher Schurr draws his service weapon and shoots Lyoya in the back of the head. Now, he claims that it was self-defense. The arguments that have been presented, essentially, I say arguments, but there's been no real arguing just yet, is that Lyoya was attempting to use the taser on Officer Schurr. There's been many experts that have testified that, and even the parts of the testimony that I don't like, taking that out, they all testified like stunning an officer is a bad thing. Like that puts the officer in a very bad spot, and that he would be justified in using force. Now, where they differ is that they're uncertain, and some say there wasn't an imminent threat that Lyoya was going to tase the officer. Yeah. So that's why I say we need the officer to testify. We need Schurr to testify in this case.
Definitely.
And what are these other 30 plus 35 witnesses going to testify to that's going to help this situation for the defense? I don't know.
Maybe they find another cop who were also on trial on a similar reason, but was cleared. I don't know.
Surprised witness standing on the other side, because all the witnesses are on the left-hand side of both actors. Yeah. And supposedly the taser is underneath Lyoya, and he's trying to use it with his right hand, like trying to reach up with his right hand. But nobody's in a position to see that except Officer Schurr. Yeah. So all the videos that we have, all the eyewitnesses that we have, all the officers that testified yesterday that showed up after the fact, nobody saw that very moment. Yeah. So what are these other 35 witnesses going to testify to that's going to help?
Yeah, one of the things that is most perplexing for me is the defense by playing the other, when the backup came, how they detained the passenger. That was picture perfect. This is how you are supposed to do. So if you compare that to Officer Schurr's conduct, I mean, it's night and day.
Yeah.
Now, the other one knew they already knew it was shots fired, suspect down, but still, it was picture perfect. This is how a stop should be done.
Yeah. So the first arriving officer testified and showed his body cam. Yeah. And he did exactly what we feel like maybe Schurr should have done when he first arrived, when he first pulled the guy over. Like if there's a guy that immediately gets out of the car, then you stay by your vehicle, you get out, stay by your vehicle, give him commands to, put his hands up, walk backwards, things like that. You don't just run right up to him like Officer Schurr did. And I agree with that looks bad. I'm not a police officer, but I've seen a lot of dash cam videos as a criminal defense attorney. I've seen a lot of police in the field, initiating these stops. And what Officer Schurr did, I can't imagine complies with department policy. Although it was testified to by the captain that he was fine. He was closing the distance and stuff like that. I just don't see that complying. But that's not the legal question. The legal question is, was he acting lawfully? Yeah. If he was acting lawfully, regardless of the procedure, then I don't see why any of this matters. But it just looks bad. Like the video looks bad. The first arriving officer and his handling of it looks bad for the defense. All of this looks bad for the defense. Hey, Michigan fanboy.
Hey.
From South Central Michigan. All right. Well, I am in the east side, but welcome to have you here. So trial should be starting shortly. Nick has the Adelson hearing that we're going to talk about while we're waiting for this to get going.
If you don't know, I've been covering the Adelson trials for almost 2 years. It is the Florida law professor Dan Markel was murdered in 2017, and they discovered quite fast that this was a professional hit, but it took some time before they took it down because there were so many people involved. So they first tried and convicted the 2 hitmen, and then they tried and convicted the middle person. Then they tried and convicted the person who paid for it, who was Charles Adelson, Shockey. And that was last year, winter of 2023, November 2023. And then they caught Donna Adelson trying to escape the country to a
North Korea or something, or I can't remember what it was.
Yeah, so they were going to.
She's the money man. She's the one that paid for all of this.
Yeah. Now Charlie was the one paying for it, but Donna Adelson is the matriarch of the Florida Adelson family. These guys are or were wealthy as fuck.
I can't believe the wife or the ex-wife, whatever, got away with this. No charges against her. Yeah.
Yeah, it seems like even do I believe she was involved in it? Yes, but she took a back seat and more or less, okay, Mom is going to fix this. Mom, please fix this. And when they said, yeah, I will fix this, and more or less told Charlie, yeah, those shady people you hang around with, make it happen, more or less. And to get, she looks like a nice old lady. But just to paint the picture of Donna Adelson, during the divorce and the custody battle between Dan and Wendy, Donna Adelson suggested they would dress up the kids in Austrian painter guy youth uniforms just to spite Dan, who was a devout Jew. Also, jokingly, according to themselves, said, let's convert them to Catholicism. So yeah.
They baptized them.
Yeah, so that's Donna Adelson for you. And now the trial against Donna has been postponed because she started out using Charlie's defense team as her defense team. And as it turns out, Charlie never signed off on that, as his defense team told the court. Yeah, he's okay with it, but once I need to see papers. And Charlie never signed off. So Donna had to have a completely new defense team, which postponed everything. So the
defense team that did such a good job that sent her son away.
Yeah.
That defense team.
I'd
probably pick a different one myself.
Yeah.
So what was the hearing yesterday?
I'm not entirely sure what the hearing was. I haven't seen it. Okay. But it could be scheduling. It could be evidentiary hearing. So I'm not entirely sure.
How do you spell her name?
With one S. Adelson with one S.
Okay.
Will we finally see the other brother in this trial testify? I don't know, because that's the brother who got away from the family, who moved up north.
Right. I'm putting this up. Data. Did I spell that right? Donna?
Donna with 2 N.
2 N's? Okay. So, all right. Yeah, so we'll watch a little bit of this while we're waiting for court to start. I look handsome.
That's
Finally made it to the gym today. I was excited about that. It's been a week.
He has full control of his courtroom.
Zoom.
Maybe we should have. I'm skipping ahead a bit.
No, man, we should just be able to sit down and then y'all get started talking to them. If they cannot hear you, or you cannot hear them.
Wow, that's weird. What is with that sound? Is someone appearing via Zoom?
This is Adelson. Can you hear me?
Yes, I can.
Oh, okay, she is.
All right.
Oh, she's in jail, right?
Check so
Yeah.
you can hear everything happening in the room. Mr. Zellman.
Josh was
Oh,
on
this was
behalf
the
of
guy
Ms.
who
Adelson.
handled her son's case, right? The
Yeah.
same judge?
Same judge, same case.
All right, for everyone who has joined the Zoom this afternoon, there is not to be any recording of the Zoom. The pool camera is the only designated camera that is going to be recording the proceedings today.
We're not sure what
We're
this
here
hearing
this
is.
afternoon on the defendant's expedited motion to
Yeah,
continue.
that's exactly
the
what I
trial.
heard.
The state has filed a response to this as well, and the defendant has filed a reply. In addition, the defendant has also filed a motion to compel. Mr. Zeller.
This is
the
a
motion
discovery
hearing.
argument. Yeah, it's
Yeah.
discovery.
Your Honor, before
Turn over
we
documents.
Do that. I believe that the email from your office also indicated that you wanted to address the scope of the sealing. That might
We're
be-
still
We'll
waiting
get to
on the
that at
Christopher
the
Schurr
end,
trial
but
to
Unless
start.
you believe we need to do it right now.
Given the nature of the materials and the basis for, in part, the basis for continuance as well as the motion to compel, we would request that it be addressed at the beginning of the hearing.
Very well. Concerning the scope of the sealing, when this matter was first presented to me, when we had the phone conference on April 8th, as it related to matters pertaining to the warrants and any affidavits and any support for those as to the investigation that recently concluded, I am in agreement with you, those matters would be confidential. However, every filing that may even reference those materials, sealing those filings starts to become a question of whether things are exceeding the scope of confidentiality that's allowed by the rule of general administration. Mr. Zellman, why should all of these matters remain sealed without redaction or other means that could be made to otherwise deal with the portions that are confidential?
Well, Judge, Jackie Fulford on behalf of Ms. Adelson, our position is that the information that's contained in the items that Your Honor is referring to would need to be referred to also in the arguing of these motions. And we're here in open court, and I'm not sure how we protect the sealing of those documents when we're going to have to argue the very materials that serve the basis of why we're here asking for a continuance and a motion to compel. The
Is
information
anyone
that's-
actually getting into the warrants or the affidavits themselves with what you plan to argue?
Yes, Judge, and the materials from the investigation.
They're trying to get
You
at
have
access
those
to the
actually
information that
bring up
formed
as
the
a part of your
warrants.
argument today.
Sounds
Yes,
like.
Judge.
Not generally, not just referencing them.
I know.
but
I
the
noticed that.
actual
I thought that was her
materials
for a
from the
second.
warrants and the affidavits.
Aaron.
Well, there need to be statements put on the record on behalf of Mrs. Adelson regarding what was claimed to have happened in the investigation that has since proven to be false, that has not been retracted by the state. And in making those arguments is part of the basis for why we need a continuance and why we're asking for the relief in the motion to compel, as well as additional depositions. And
To that end, Ms. Dugan, is the state planning to file any superseding indictment or any additional charges based on the investigation that is now concluded, or at least is alleged to have concluded?
No, sir, not to my knowledge.
With
Yeah.
that being said,
The state
if the
in
defense
this
is
case
seeking to file an
often
motion
sends a
related to these
junior
matters,
assistant
they are not related to
prosecutor
pending counts.
to the
However,
hearings,
you can
so she
pursue
can
them
always
as
say,
they
well, I
believe
don't
them
have
to be
this, I don't know
appropriate.
about this, I have to bring it
As
back.
to the warrants
to the
and
DA's
applications,
office.
does the state
So they
have
are
a
kind of
position as to
stalling
whether
this.
they should remain sealed or any documents referencing them should remain sealed without redaction?
No, sir. We would defer to the court. And some of the discovery the defense has moved to compel is sealed, or a lot of it is. And I actually brought a
We're
motion
watching
to
the
unseal
Dana
documents
Adelson
and
hearing while we're waiting
recordings
for court
related
to
to
start
that,
on Schurr.
today, so
Yep.
that those can be provided to the defense, either, but maybe for the limited purpose of discovery, but whatever the court prefers, we don't have a position.
Mr. Sullivan, Ms. Fulford, any additional argument?
No, Your Honor.
With there not being additional charges to be filed by the state concerning these matters, the court is going to unseal at this point the filings that have been previously filed under seal as it relates
I need to
to the
get a hold
motion
of
for
those.
continuance, the state's
Yeah.
response, and also the reply as well. Any other matters that need to be reviewed by the court or to be unsealed from here, the parties need to appropriately raise.
Can we have just a moment, please?
Go ahead.
Morning, Jung.
Hey, Joe. Oh, Olan Red is here. Yeah, it's just Dugan for the state.
Yeah, this is just a it's just
Evidentiary
an
hearing.
evidentiary hearing. They're trying to get access to documents that supported the warrant, is what it sounds like.
Your Honor, if
And
if
the
I could
state's
just
being
ask for
shady. Who would have thought?
clarification, are you indicating that you're unsealing the pleadings, but not the actual underlying applications, affidavits, and warrants, or you're unsealing
Not the
everything?
warrants, not the affidavits, not the applications, but pleadings that reference those matters, yes.
Just one moment, please.
Interesting.
Yeah, you would imagine that they would, if the matter is concluded, then it should be,
That's an opportunity to propose redactions.
unless
of
they are
pleadings,
planning for
given
additional
that they,
charges
relate
against
directly
other
to
suspects.
those underlying materials. In fact, in some points, quote them.
Absolutely.
Thank you.
Again, as to redacting those matters that would remain sealed, that is certainly appropriate under the rule of general administration. As to each doc or each docket entry or each document itself remaining sealed, just by incorporating by reference those matters, I believe that's getting a little bit further than what the rule requires.
It is May Day.
Hmm?
Burn
Mr.
witches
Zeldin, you may
today.
make your argument at this point.
Your Honor, the expedited motion to continue that was filed on April 21st. I try to make my arguments as clear as possible in the written pleadings. What has come out about 3 weeks ago is the state conducted this additional investigation into allegations. As part of that, they obtained additional records. We also learned approximately 2 weeks ago during Investigator Newland's deposition that the state had not given us materials. That
I don't
had
know what a
been
Mayday
given to
basket
prior
is, Jim.
counsel. So we've
Oh,
been asked to trust without the ability to verify. And in fact, months ago, I asked
Like
the
an
state
Easter
for a
basket?
list of the materials, everything that they had, everything that Corbett had, so that we knew if we had received
we are
everything.
going into discovery violations
And
by
they
the
did not
state.
provide that
In
to us.
Florida, who knew?
So now,
Yeah, who
we
would
have
have thought?
received, from the materials we received over the last few weeks, it appears to be over 100,000 emails. We have purchased 3 pieces of software in addition to the software that we used previously, trying to,
Is this to sort through or sift the emails?
some of it's to
Hey,
open
didn't ya?
it, some of it's to sort through. Yes, Your Honor.
Go ahead.
None of them are very effective at.
Yeah, we got raided
So
by
we've
Mo.
actually engaged.
Oh, I got raided by Mo. Hi, Mo
To
Raiders.
assist us, but
Hello.
that hasn't even been set up yet. That was a decision that we made last night after trying.
We were watching a little bit of the
yesterday.
Donna Adelson hearing
In
before
addition to
the
that,
Christopher Schurr trial starts.
We have.
I will cut out
new,
this as a separate
cell
video
phone
on my
extractions
channel.
from,
I don't think Dave is
Mrs.
covering the
Adelson's phone.
Adelsons.
I understand
not.
the state's response to the motion to continue that they don't intend to use any of that, but that doesn't mean that there's not something in there that we want to use.
And I did want clarification on that point. As to the discovery provided to prior counsel, Ms. Dubin, the response of the state is that on October 31st and November 8th, the raw data from the defendant's phone and email accounts were provided. Is that correct?
I mean, I thought this
Is
woman
that
was
what your
guilty
response is
halfway
getting to?
through her son's trial. So
Yeah.
Is this concerning, can you tell me?
Just-
I
just
don't
the
know
raw
why
data
the
from
state
the
in this
defendant's
case keep
phone and email
being shady.
accounts.
Because
Yes, sir. Those have all.
They have all
been
the evidence.
provided. I thought he was talking about the.
yeah, I don't know why either.
We're going to get to the filter team documents. The best way to do this is to take it into bite-sized pieces so it's clear what is going on.
Thank you for rating
what is
Nick
not.
Mo.
Yes, sir. So it's my
Thank you,
understanding
you.
that all of Mrs. Adelson's phone records were previously provided in November 2024. There were certain phone records, I believe it was 7 pages of phone records that were actually, this is going to be paragraph 7 of the defense's reply to the response. These are phone records that Donna Adelson's prior defense counsel had an issue with us not having. So these were subpoenaed. TPD received them in October of 2024. The state attorney's office didn't know TPD had received them. TPD didn't know that we didn't have them. And so that's why they weren't disclosed. But ultimately, they
the
have
state
known
is the state is the state.
Another term you start to hear sort of thrown around a little bit more by
That was
Ultimately,
annoying.
though.
Go ahead.
Yes, sir.
What was that?
Who
Who was talking?
So
Somebody who got
those
themselves
were the
into
7
the
pages
Zoom,
that they
I
did
guess.
not have,
It's awesome.
that weren't disclosed to them last fall. That's my understanding. And we would object to a continuance based on those pages.
All right, as to any additional raw data from either your client's phone or email accounts, are these not in your possession at this point?
We have them, but that's the materials that we've been struggling to try to get through.
And again, this was disclosed back in October and November, or when did you receive it?
We did not receive those materials, Your Honor, until it was after, if Your Honor recalls, during the expedited hearing that we had a couple of weeks ago by telephone with the state and defense on the phone. Those were the records that we were addressing then, and I believe that we got those. April 10th, 2025. And that's, the state actually acknowledges that in their response.
So they got all these materials
All right, Mr. Zellman, you're
less than 3 weeks
not going
ago.
to make your argument for you, but ultimately you believe you need to review these to be prepared for trial itself.
Yes, and those aren't the only issues that have arisen over the last few weeks. The motion details the additional issues.
Yeah.
But
Actually,
Right.
needless to say, we have
it's the
spent
5th
the
try.
last
They had
3
to
weeks
retry Catherine.
trying to collect this material, some
No,
of
wait
which
a
we
minute.
still don't have.
I don't know. It's
Yeah,
been a
no,
few
this is
trials.
right.
Referring to the
Enough
recent
trials that they
motion.
should have all this
Yes.
stuff.
Yeah.
Go ahead.
And even if the state isn't going to use the information, we still need to know the extent to which they violated, they intercepted and monitored attorney-client communications and communications that are protected by the fiduciary client privilege. We don't have all of that information yet, and they have not responded, as I indicated in my reply yesterday. The state hasn't responded to those emails requesting that information.
Ms. Dugan,
Yes, sir.
concerning the aspect of the recent investigation, which materials are yet to be provided and why?
Yes, sir. May I also address the 100,000 emails?
Go ahead.
Okay. So those 100,000 emails are redacted privileged communications that the defense recently received that occurred between the Adelsons and prior counsel. This communication
It's like the
was
good old
redacted
days,
by a
Nanya.
team. It's never been seen by the prosecution.
The filter team document
Yes,
you're
sir,
referring
thank you,
to.
filter team. It's never been seen by the prosecution. It's obviously privileged. We obviously do not intend to use it in our case, having never seen it. And I also can't imagine a scenario where the defense would be using it in their case. I would feel like.
Why wouldn't the defense want to use if they need to see the communications to see if there's anything in it to that clears law?
Right.
Even if it's attorney-client privilege information,
When were the filter
that
team
can, that
documents provided?
certainly was
They
waived by
were
Donna
provided on April 10th during
about those attorneys, the prior attorney.
During
Yeah.
Jason Newland's deposition by this defense team, somehow some question was asked where he referred to the filter team that the court referenced. And this defense team was not aware that the filter team had gone through all of those emails and kept all of the privileged emails from the prosecution team and provided them to former defense counsel. So those were then provided to this defense team.
Very well.
And Your Honor, I could address that very briefly. Judge, advice of counsel is something that would be relevant. It goes to Mrs. Adelson's state of mind. And if there are any emails in the records that we received 2 weeks ago that would rise to that level, then it would absolutely be relevant and admissible if it goes to her state of mind concerning, for example, her leaving the country.
Well, I was going to say, particularly as to that issue, what advice she received and what she relied upon in making that decision, that would be up to the finder of fact to determine, was she relying on the advice of counsel or was she in fact trying to flee? The emails, though, and your client does not have to testify, but ultimately this would go to how would the emails themselves be admitted versus her giving her recollection or recitation of it.
Oh, they're trying to get at the emails between her and her counsel?
Between Rauschbaum, because since Charlie never signed a waiver, they already concluded it had a conflict of.
Not be admissible, Your Honor.
But that doesn't remove attorney-client privilege.
Yeah.
Let's put a pin in that. That'll
Yes.
be subject to any argument in the future.
Yes.
as
This
to
is one
how
of the same
emails
issues that the
themselves can be
Crumley
admissible.
parents had.
But if your
Yeah.
client chooses to take the stand during the trial and waives any prior privilege.
Or any
with
bad
Rauschbaum
advice
or
from
anyone else
Rauschbaum,
concerning advice that she
her
received
prior attorney,
on leaving the
are
country,
still under
that is
privilege.
certainly up
If
to
she
her.
waives that, she might waive a lot of things.
On the
Yeah, who knows
back
what
to
she
the
said to him,
instant
right?
investigation, discovery, Ms. Dugan, the items that have not been provided.
Her fleeing is a
I
major
believe
part
some
of
these
the state's case
pertain
against her.
to the parameters
And if
Right.
that was
in
on the
Title
advice of her
III
prior
that
counsel, you have,
we're
Yeah.
supposed to operate as safeguards. Is there a reason this has not been provided to the defense?
yeah, I like this judge as well.
So looking at the reply and the motion to compel, all of the things that they are requesting here as far as the minimization instructions, all the logs, all of those things, I feel once the order to unseal has been signed, those can all be disclosed. The only
dropped
thing
some
that I
of my Lego.
saw that would be additional that they are asking for is surveillance video, which is surveillance video from the jail, which I've been told has already been disclosed to the defense. They also
But
asked
wasn't
for
she
the
talking a
financial
lot in the
records
jail?
that are mentioned in the application.
A lot.
I was told that we subpoenaed Harvey Adelson's
I mean, she's
Zelle
been going through
account.
years of
I
legal
found
issues
that
with her
Zelle,
kids and
those
didn't
Zelle
pick up that
records
one.
and had
Like,
it sent to
don't
the
talk to
defense
anyone
this
about anything
afternoon.
ever.
So once those items are unsealed and they can be disclosed to the defense, that should be all of the discovery that pertains to the wire.
Please provide the order. Has the defense been able to take a look at it?
No, sir. Let me show them what I have, and if I need to change anything, I'll happy to.
Yeah, I mean, Donna Edison communicating with her son in jail, talking about, yeah, we're going to Vietnam. One-way tickets. Yeah, not the brightest of ideas. If she hadn't told her son, they probably would have been in Vietnam, who
Right.
doesn't have an extradition agreement with the United States.
No plumbing in the treehouse yet, Dave. I'm working on that. That's a summer project.
Yeah, also speaks to Donna Edison's character.
You may.
She was perfectly okay with abandoning her son in jail, in prison, and her
Student
daughter,
and I addressed concern in the motion and order.
and bringing all the money with her.
With Investigator Newland's memorandum, the 17-page memorandum. The memorandum that he authored indicated that the wire went down February 24th.
Well,
Ms. Dugan
that's
is telling me
that's
that the wire
true,
actually
I
went
suppose.
down
Silver lining.
February 1st. So, we can just make sure that that's accurate.
Yes, this is one of the paragraphs in the defense's reply. That was just a mistake on the memo. The wire came down on the 21st. I believe the significance of the 24th was that was when the order was signed, and I think Mr. Newland's memo said the 24th, but it is the 21st, which is reflected in the order the court's looking at now.
All right. Court will sign the order at this time. I believe that deals with your motion to compel, Mr. Zellman.
May I address one more thing about the issue we were just talking about? There is obviously this new discovery from this lead that the state was alerted to last fall. We conducted this investigation and followed that investigation to its conclusion. That obviously has resulted in some new discovery in these wire calls, but I did want to let the court know, though there are a large number of calls that the defense, of course, wants to review, there are only, I was told, about 30-something calls deemed pertinent by law enforcement, and the state likely plans to only use maybe one or two at trial, and believes that the 2 months the defense had from the time it was discovered to the time of trial in June should be sufficient to prepare for that portion of the trial.
Do any of the calls that
Oh,
you
I did.
intend to
I
use
did.
from this recent investigation go to privileged matters or encapsulate
Thank
calls
you.
with counsel?
There we go.
Thank you. I
How's
wanted to
that?
address
That's better.
that. There are no
It's
calls
early yet.
that were reported between the defendant, Donna Adelson, and attorneys in this case. I specifically asked the investigator about that before the hearing.
Mr. Zellman, you may continue with your argument.
Yeah, this was 2017, the murder of
Sure.
Dan Markell. So this is 8
The
years.
state has
They
also
are
not
still providing
responded to our
discovery.
request to,
Crazy.
to
Well, this is particular to
know
her.
if
It's
they've
more
also
recent
been monitoring
communications. I get
our
that.
attorney-client conferences at the Leon County Detention Center.
That's a no.
And although the state believes that we're going to have enough time, I calculated this. There are over 32 hours of calls that were captured on that wire.
32 hours?
And given the amount of materials that we have just been
Yeah, she's a
handed,
talker.
we have not had an opportunity to review even 2 hours of those calls up to this point. Your Honor, just because the state believes that there's going to be enough time for us to prepare, and it's not 2 months, it's more like 6 weeks.
Good
There's
afternoon.
not enough time for us to obtain, to analyze this new information, synthesize it, prepare appropriate motions. We've spent the last 3 weeks dealing with this as opposed to finalizing the motions in limine.
That is an important point you bring up. Essentially, between what has been recently investigated and what the charges have been of murder, solicitation,
Oregon would be the
conspiracy
left coast there,
from the
Dave.
time your client is charged, there are essentially two different pots, if you will. For the motions that the deadline was today as to the murder solicitation, and also the last count as well, are those motions completed?
No, Your Honor, we've only had an opportunity to finish 2 additional motions that have not yet been filed, and I have not had an opportunity.
I thought that was her too at first. That's her attorney.
Learn this continuance
Donna is
position,
apparently
to finish the Frank's motion.
via
She's
Zoom.
in jail watching
Yeah.
from Zoom.
Right? So you are in fact asking for an extension on the deadline to file your motions.
We're going to need one in addition to the continuance. Yes, Your Honor.
Ms. Dugan?
If the court wants to give an extended motion deadline, we don't have any objection to that. We do object to a continuance of the trial and remain ready for trial.
What is the
Yeah,
defense?
she looks like her
Before I come
attorney.
back to you, Mr.
You don't want an
Zellman,
attorney that
what
looks
is the
like you
prejudice
or
that the
acts
state
like
would
you.
suffer if the trial is continued, Ms. Dugan?
We would not,
Beyond just a mere objection.
we would not suffer prejudice, Judge. We're just ready for trial if it goes as
You
continued.
just handed over new discovery.
Zellman, what would you be proposing as a date? And you also have to keep in mind, there's only so many points in the year a trial that could take either 3 weeks or more can be scheduled. And I assume you've discussed with your client if your relief is granted,
We have.
what that means.
We have, Your Honor, and frankly, without getting through all of this new material, it's hard for us to pinpoint exactly when. I mean, we're not going to sit around on our hands and do nothing. We have been diligently preparing. We're going to continue to diligently prepare. Likely 2 to 3 months would be, I think, realistic. But again, until we get through all these new materials, it's going to be hard for me to say.
Right, concerning the motion deadline, which was supposed to be today, we will set a new deadline, particularly as to the counts that have already been a part of the indictment and have been charged all along. The murder, the conspiracy, the solicitation, the deadline for filing any motions relating to the existing charges will be May 16th. The motion hearing that was scheduled to take place on that day, we will reschedule at a later point. Court is going to reserve ruling as to whether the motion for continuance will be granted. The parties are to confer about any redactions that you believe would be appropriate to the filings for the expedited motion for continuance, the state's response, and also the defendant's reply, and the motion to compel discovery. Any other matters that we need to address before we finish up for today?
Your Honor, with respect to the motion to compel, the state has also not provided the disclosures that's required by Rule 3.2201BM concerning the jailhouse informants. We've also.
They're going to use
that
jail
material
snitches.
as well.
Well, she's a talker, but I so much hate
Give me a moment. I'm
jail
going to bring up the
snitches
rule.
because they have everything to gain by lying.
I have a feeling I might believe these jail snitches though.
Yeah,
just
these
a
might be more
hunch.
credible because Donna Adelson cannot stop talking.
38 hours of jail calls.
Yeah.
I believe she might have said something to inmate or
Yeah.
two. Did I know
So
that
this
Aaron
is
Heck was in the
1
Twin
in
Cities?
which subsection?
1BM.
I have
1B.
24 degrees Celsius, so it's closing in on 80 degrees Fahrenheit in Sweden.
Well.
It's quite warm for May 1st.
We decided we're going to visit Sweden
Sweden
for a bit
response.
in June
I'm
and
sorry,
then go to
Judge,
Iceland to see the
I'm
24-hour
waiting on the
daylight.
Wi-Fi. Is there,
This is in the discovery rule under the
Yeah, but I don't
prosecutor's
remember your
discovery
address.
obligation. And I will quote from it.
Thank you.
whether the state has any material or information that's been provided
Depending on
by
what's
an
in
informant,
this
witness,
new
proving
material, I
substance of
think
any
they
statement
might
allegedly
have to
made
ask for
by the defendant about which the informant witness
continuance
may testify,
of the trial
the
start.
summary of the criminal
Because
history
that is a
record of the
lot of
informant
jailhouse
witness,
calls.
the time and place under which the defendant's alleged statement
Too
was
much
made,
sun coming in.
whether the informant witness has received or expects to receive anything in exchange for his or her testimony, the informant witness's prior history of cooperation in return for any benefit is known to the prosecutor.
Yes, sir.
Maybe Mudge
thank
will
you. I'm
show up
familiar
in
with
this
that
trial.
role, but just didn't
He
know
moved to Florida.
All of
Yeah.
the different things we needed to show there. Some of that has already been provided through the recordings. However, as far as her history, any benefit, all of those things. we'll disclose that,
That's it, Aaron. That's what happened.
as soon as possible.
Please disclose it by Friday of this week by 5 p.m.
Yes, sir. And may I also ask about today is the discovery deadline, which the state is prepared to obviously comply with. As far as though now the order on the continuance maybe being later in the week, would it be okay if we had a discovery deadline of 24 hours from the order, or would you rather keep it for today?
Concerning, again, the charges that have always been in place, the murder, the solicitation, and the conspiracy, is either party seeking more discovery on those charges that has not already been addressed up to this point?
Judge, the issue with complying with today's deadline is we have spent the last 3 weeks dealing with these other issues. We have
Not the motions. I'm saying, are
I'm
you
not-
seeking additional discovery on the indictment charges?
We are not going to be able to meet the deadline to provide the state with our discovery because we have been focused for the last 3 weeks on other issues.
Ms. Coogan?
The state can.
When's the trial
comply with
supposed to start?
discovery today.
Well, it
I
was
just didn't
supposed to
know
start
if-
in end of last
given
year.
the
Then it was moved
possibility of
up
the case
to
being continued this week,
more or less now.
if it were possible to have
And
24 hours
then it
after
was
that order
moved
came out.
to September
But
or
if it needs to be
October.
today, the state can comply with that.
And it
and the
seems
state
like
would-
it's going to be
hope that the
postponed
defense can comply
further.
to or get
Yeah,
discovery.
the woman that's
as possible.
charged right now is the
This
mother
ruling has
of a
been
guy who
made
was
on
convicted
the
for
continuance of the trial.
soliciting
The court will also
the
address
unaliving
the
of
deadline
his
for
sister's
discovery as well.
ex-husband.
For
and
now, please operate as if the
The
deadline remains in
accusation
place.
is that
Wait
this
for the order.
woman conspired with her son,
Judge, I just
Yeah.
and
wanna
he was
make
convicted
it
last
very
year.
clear,
And then
there's no way we're
there were
going
a
to
bunch of other people that were convicted. So
work
there's been
straight
multiple
through
trials
till
in this, and this is probably the last
Again,
person
Mr.
that's getting
Zellman,
charged.
as to
Probably.
that, what can be filed, please do.
Yes, sir.
I will let you know once we have a motion. Or,
And they're
excuse
all
me,
like
once the
extremely
order is on the
wealthy
motion to
dentists,
continue,
doctors,
whether the
attorneys in
deadline
Florida, right?
for everything
Yeah.
else related to today's deadline.
They are an
applies as
offshoot
well.
of the Nevada
We are
Adelsons, who
recessed.
owns half of the strip.
Ah,
For everyone on the Zoom, that is the end of the hearing today.
okay.
Hmm?
So the judge is giving him a continuance. No known new trial date. They're going
Yeah,
to get some discovery exchanged. It looks like the bulk of it. So I see what the problem is. So the Donna relied on her son's attorney to advise her legally, and that's the subject of the discovery request. They're trying to say that that's attorney-client privilege, which it might be, and therefore undiscoverable. But if they want to use her trying to flee to Korea as consciousness of guilt, then she might have to, or she might want to, for strategic
Yeah.
purposes, waive that
A
privilege.
limited waiver of attorney-client privilege to that alone, which
Yeah.
I
Well, who knows what
understand.
else they said to each other? I
Yeah.
think if you waive the privilege, you waive all the communications, especially because he's not the current defense attorney. There's somebody else. I don't know. This could get kind of messy.
Yeah. All
It's
right,
but the same issue that Jennifer Crumbly and James Crumbly had with their case, and that the whole consciousness of guilt aspect was used against them, and then they had no way to defend themselves because the attorneys that they were speaking with were their current attorneys in the trial.
Yeah.
It's all kinds of bad.
Yeah, I'm not familiar with if the court can grant a very limited waiver of attorney-client privilege, especially in this case where this is a prior attorney.
Jung and her K-pop. She was there just to see a band in concert. That's all she was going for, right, Jung?
Yeah, she was not at all trying to move all her money to a Vietnam bank and move herself and Harvey to Vietnam.
That's not a bad idea, though. If you're going to, like, go to a country to, like, flee the justice system, buy a concert ticket for a band that you really like, and then, like, go to that country, be like, I was just going to see this band,
Yeah. And in a prior hearing, Donna testified to the court. Now that will never be listened to by the jury unless she takes the stand. But that no, she was going there so they could turn themselves in under their own. They just needed to clear their heads. If the arrest warrant came, then they would travel back, as if you can't do that from within the United States.
Hey,
they could have just gone to Michigan and handed themselves over from there, but no, Vietnam, non-extradition.
Yeah, no. Well, that's where BDSM is, or whatever that K-pop band is. All right, so we have trial in Christopher Schurr. We are going in that now. It is we're a little bit behind, but that's okay. I'm gonna pull up this other stream, even though it cuts off a little bit of the beginning of the here. It's only like a minute that it cuts off, but because we could do closed captioning, I think that would be better. Yeah. So this is what I was gonna pull up. And for some reason, it starts off with the judge on the bench, and then it cuts to this, and then the officer, Captain David Siver, is still on the stand. So this is the witness that's going to be on, and he is subject to cross-examination. But let's get into this. BTS, David. BDSM sounds better. Sounds more accurate.
You're a listed witness, so what are you going to testify to, correct?
He asked me a few questions, yes.
And one of those questions was, does GRPD have any policy or training that directly addressed being disarmed of one's taser or being confronted with a taser? And you said no.
Yes, it did.
Okay. And once again, this thing that you signed that was provided by the defense, you talk about close quarter deployment of the taser, you talk about drive stun of the taser. There's nothing in the statement that you put about being disarmed of the taser is considered deadly force, correct?
Correct.
I guess, did you know what this was for?
I did.
What was your understanding this was for?
The areas that I would be asked to testify about.
So that skipped your mind with it, or you didn't say, hey, I was going to testify about how being disarmed of a taser is deadly force. You just left it out?
I wasn't asked. It wasn't provided, and that's that.
You didn't read it?
I read it, yes.
Okay, so what they're going over, where we left off yesterday, was this officer wrote an affidavit, which was like 4 pages or something, compared with the state's experts that wrote, 28-page opinions on this case. Now, this officer is qualified as an expert with regard to Grand Rapids police tactics, and now he's being cross-examined on that affidavit. And it sounds like in that affidavit, he said that an officer being stripped of his weapon is dangerous and deadly, but he didn't testify to that. So I think that's where we are. Hopefully that makes sense to everybody.
Signed it. I read it.
Well, you knew at that point, because this was last Monday. But we're starting jury selection. You finally filed something last Monday.
Objection, Your Honor. This was in response to his expert.
Starting out.
Legal basis. This is not relevant.
Yeah, the prosecutor did not cool down at all over the night.
Nope.
Our motion to exclude his expert for certain reasons.
this is the only report we got from him, so I think what it's a statement.
Oh, he definitely isn't
This
happy.
is a summary of his testimony, and it was in rebuttal to the prosecution's experts.
So you're saying it's not relevant?
Not relevant to this. This is not, we have provided, as we provided Mr. Record with a summary of what his testimony would be at trial as required under the court rules. He's not required to provide an expert report, and the investigator had a chance to talk with Mr. Schurr.
Okay, so I'm not sure how it's not relevant. So.
It's taken out of context. This is not saying this is what
I
it
will
is.
definitely allow you to flesh all that out in the record. I don't
This
think
looks like
it's
they're
not
scared of the
relevant,
cross.
so
This looks like the defense is scared of the cross, and that's not a good spot to be in.
But if he authored an affidavit, and also his response could also clarify that, so.
All right, so he's qualified as an expert witness. An expert doesn't have to produce a written report in Michigan. Other states could be different. But if he does produce a written report, it has to be turned over to the other side. Now, so this affidavit was turned over to the other side because he produced it, he signed it. But the defense is arguing that it's not relevant because it wasn't actually introduced during his testimony. It's not an exhibit. The judge is right here in that the prosecution can use it to cross-examine him and impeach him with it, though. So again, I agree with the defense or with the judge. I don't agree with the defense, and this makes him look scared of his own affidavit. This is not a good posture, and this is all in front of the jury, folks.
Oh,
Yeah, this is all in front of the jury.
oh, this is not good. Why are they having this in front
There's
of the
nothing in
jury?
that statement.
We do it very often. In
You
Michigan.
wrote,
I don't
it
know
was
why.
provided to us on Monday. The day we started jury selection, we get this. That's the first time we had anything in writing from you. You don't say anything about.
That is not,
And you're testifying, so.
We coordinated this morning,
I
John.
have a right to lead the witness, Your Honor.
Right, you can't, you're making a statement of fact, and so.
Okay. You've never written anything down about this, have you?
About this incident?
Yes.
Yes, I completed a police incident report
Where is it?
in our system. I'm assuming you have it with the trooper's investigative report.
It was never provided to us. You know why? We did a search warrant.
That's not my purview or responsibility, sir.
But in terms of you didn't do an expert report.
I did a police incident report,
But you
yes.
didn't do an expert report.
No,
And you, at no point in time in your incident report, did you ever talk about tasers, deadly force if it's taken away from you?
no,
You at least, and then you didn't tell the officer, or excuse me, the trooper, when he showed up at your, at Grand Rapids Police Department to talk to you about it. You never told him about that.
no.
Just skipped your mind?
It didn't seem, I didn't talk about it.
He asked you specifically, do you have any policies about disarm of a taser? You said no.
We don't have a specific policy about it, no.
But that would be a big thing. We don't have a specific policy or training. He said policy or training, and your response was no. How does that not seem to be a legitimate response?
It didn't seem to be.
Okay.
I do like this is a seasoned
Tasers are
officer,
different.
though. He's used to
Yeah.
being cross-examined. He's calm, cool. He's just like, hey, I'm just giving you the information, man. You can get as angry as you want. I'm just giving you the information.
Yeah, that's
I
true.
mean, he didn't say specifically a taser yesterday. He said disarmable weapon.
Correct.
Okay. Is an OC spray a weapon?
Potentially, yes.
So if a person's disarmed of OC spray, if a person disarms an officer of OC spray, that's deadly force.
No,
Well, isn't a taser and OC spray the same thing under Grand Rapids policy?
it is not.
I'd like to go to Exhibit 32, Your Honor. You put it up on the board, please. Excuse me, 30. This is Exhibit 30. So you have a policy. You have a separate policy for firearms, correct?
We do.
It's its kind of own entity. So you have a firearm, that's kind of the highest. You agree with me, firearms are deadly force, right?
Yes,
No question.
yes,
So then you have intermediate control weapons. That would be the next step down, if you will.
yes,
And then you have compliance control devices, correct?
we do.
That's kind of a three-tiered thing. Is that a fair assessment?
I would consider OC spray a lesser than that tier, but yes.
OC spray lesser than what tier?
Then a taser or compliance, less lethal tactical weapons, specialty munitions.
Okay, clearly, okay, let's go impact weapon use. So we got an impact weapon. Right?
You said exhibit 32.
This has been the most spicy this case has been like fun, and everyone's been like a little too happy to testify at times. This is the spiciest that it's gotten so far, but I'm down for it.
Exhibit 30, Your Honor.
Camera guy
This is the first
is
page.
still
Oh.
he's in a Michael Mann movie.
He's insane, the cameraman.
9.3. So impact weapon use. The purpose of an impact weapon is to provide officers an effective control option when confronted by potentially violent subjects. So impact weapons provide control of subjects by creating temporary motor dysfunction that impacted muscle groups. So an impact weapon would be your ASP.
Yes,
Could be a flashlight. I think that causes a flashlight, something you can hit somebody with.
correct.
So that's an impact weapon, and you use it in situations where it's kind of a confronted by a potentially violent subject. It's a little bit more a higher level, if you will, because they're potentially violent. Is that a fair statement?
Yes.
Gonna go to 9.34, then you have aerosol restraints. That would be pepper spray, right?
Correct.
The definition of ASR is to provide members, being the police, safe and effective control option. Temporary control subjects will provide a degree of safety for both the officer and the subject. That's under section E, correct?
Yes.
Right underneath that is electronic control devices, your taser.
Yes.
It's the exact same definitions as a OC spray, isn't it?
Yes.
So in your mind, you think it's different, but under Grand Rapids policy, OC spray and tasers are the exact same thing under definition.
We were told 40 witnesses total for the defense.
Yeah.
They have 40 witnesses. I hope they don't. I hope they don't call out. I don't know what 35 more witnesses would be. I have no idea. But
No,
that's what we were told.
I mean, they had their their expert, they had their colleagues. I'm not sure. Yeah, as you said, what are the rest of them there to say?
Yeah, I don't know. I have no idea what else they would say. So the position that Lyoya and the officer were at the time, nobody saw the taser, whose hand it was in, how it was in the hand. We get a little bit of a glimpse in the video, but nobody's really there on the right side of both of their bodies. Everyone and all the videos are on the left side. So who else are you going to call except for maybe the defendant himself? I think he needs to testify. I don't think this needs to be drug out for 40 more witnesses or 35 more witnesses. I think after this guy, maybe one more, depending on what information they have, and then call the defendant and be done. Well, we'll see.
Yeah.
In a definition,
the defendant was
not
gonna
in the use
testify
of force
today.
policy or under a force understanding.
Under what force understanding? This is your policy that
That's
gives the same definitions.
This is a definition policy that gives an example, not our use of force policy.
So where in the use of force policy is it differentiated, I guess?
And the levels of force options that are available to officers
So you're talking about the active aggression, active
in that area, yes.
in that area. So in the policy, so let's go look at that, man. Policies here.
Thank you. Now, my birthday is not today. It's my birthday week. But in Sweden, our birthday are connected to our social security numbers. And I don't really want to reveal too much about that. More or less, if you have my exact birthday and where I was born, you can figure out the social security number. So yeah, Sweden have a really, really bad system.
Yeah, but there's only like 10 of you, so it doesn't matter. My knees were sore from sitting all day yesterday. So every once in a while, I got to stand up.
Okay, is this what you're talking about now, or is it 32 now, Your Honor?
That is a old use force policy, sir. That's, the bottom right date says 2017 on it.
Yep.
What Officer Schurr would have been expected to adhere to.
Welcome.
is
You get some fun
2021's
emojis and
policy.
maybe in the future some
This is the one that was provided to us
videos.
under these are the training records provided to us. Exhibit 32
Yeah,
is the training
welcome.
records provided by GRPD for Officer Schurr. So you're
Yeah.
saying we weren't provided
Davis
with
finally
That's a
monetized
training
2
record,
years
sir,
after he
not a
retired
policy.
from streaming.
Updated policy should have been available to you. I don't have that.
So
I'm
what,
not, and that's not my purview.
you're the policy, you're the training person, you're the training.
Right, but I wasn't, that's not my responsibility for record release. I mean,
So there's
No,
some
it's
other
not like the
policy
David
out there
system
that
where the
says
social
that
security
will
number is
state
both a
tasers
login
can
and
use
a
the deadly force
password.
that will be able to, the folks can put up on the thing.
I'm very happy about that.
Sorry, I wanted to pause it so you could get into that because you're talking more about taser force or taser use policy.
Hi,
What do you
Wim.
get?
Member for 21 months. Hi from the hospital. If you are in hospital, I hope you get better. If you are there visiting, I hope who you're visiting is getting better. And thank you for being a member for 21 months. And here's Totally Pip. How many candles will you be burning, Nick? I can't burn those and that amount of candles because we currently have a fire ban in my county.
We almost set the house on fire when I did my mom's birthday cake.
Yeah, but let's say it's 50 plus.
There you go.
How many?
There'll be another policy that the defense can put up there then that says tasers are considered deadly force, the Grand Rapids Police policy.
no, sir. I was just pointing out that
They've been amended for 9
2017
months.
policy 2021 is the latest that Officer Schurr would have been expected to adhere to.
Now we'll stay right here.
I think that time is off because we're not that far behind. We're only like 29 minutes behind.
Hmm.
The time in the top right corner.
We were talking about this 9-1.5. You brought this up in your testimony yesterday.
Yes.
This is one of the considerations, the totality of the circumstances that Grand Rapids Police consider.
Yes. Some of them. Yes.
Some of them. Well, when you're looking at it, and when you're looking at the totality of the circumstances, your opinion was it was okay for the defendant to chase after Patrick that day.
Yes.
Because this is, use of
Mind you, the state's expert testified that if a suspect runs past the front of his bumper, you don't pursue him, which I think is an insane policy that no police department ever trains for. It's just ridiculous.
I think the most concerning there is, there's a passenger who you don't know if they are armed or not. Why approach at all?
Yeah.
Especially when he's not following direct orders.
Yeah, why go right up to the guy who just got out of his car fairly quickly and potentially aggressively, right? Just stay back.
totality of use of force. It's all uses of force. It's not just deadly force. It's force at the beginning, force at the end, force in between, right?
Correct.
And it's got to be objectively reasonable for the entire time, right?
For the use of force duration, yes.
Okay. So that use of force in terms of considering that it was a good idea to chase, let's look at right off the bat, the moment to chase. Patrick's bigger than him, right?
Yes.
There's two people. There's one in the car and Patrick.
Correct.
Right? Relative strength, we already know it, but this is before the chase is taken off. Patrick's stronger than him because as you throw in your testimony, he lifted him off the ground.
He did.
So he's bigger, stronger, there's more than one purpose, and may have an access to a weapon, right?
Correct.
So on the first four things, the first top four things to do with, so he's bigger, stronger, there's more than one purpose, and may have an access to a weapon.
He graduated the police academy in 2015. Yeah. So
in his early 20s?
Yeah. So 7 years he was on the force. And he received glowing reports, apparently. No negative complaints that I'm aware of while he was a police officer. This is the first negative thing.
Right? Shaq says, why pull anyone over by that logic? No, it's not the pulling over. It is
the approaching.
The approaching.
Yeah.
Yeah. Because the guy was already out of the... When the guy went out of the car, refused to obey orders.
Why walk right up on him is my question. And again, that might be violation of policy, but it's not illegal, which doesn't remove the officer's right to self-defense. So,
yeah, and when he went up there, all of a sudden he knows there was a passenger.
Yeah,
and yeah, so there's so much. Well, hindsight is 2020, but again, the defense did a huge mistake in showing when the backup came and how they conducted themselves.
Yeah, I think he needs to take the stand. If I'm on his defense team, I'm gonna really encourage him to do it, even though it's his right to do it. I can't make him do it. I think he needs to. He needs to convince the jury that he was in fear for his life at that moment and that it was justifiable. Otherwise, I don't see a way out of it for him. Unfortunately, I just don't. Yeah, and Potter had terrible jury, but world-class attorneys and a good judge. I think we have the opposite here. Hopefully, there's a great jury because we don't have world-class attorneys or judge in this case. Yeah. So we'll see.
First four things.
But the jury has to say.
First top four things, if you will. All of them count against the defendant chasing after Patrick, correct?
It's factors, yes.
They're factors. So what are the good factors, I guess, in there that would allow for a chase?
It's also a compressed time constraint, his decision making of deciding to
I don't know what's
pursue and then actually trying to physically restrain or arrest. Those are all happening in split-second decisions, not long drawn out.
Sure.
Working through them.
Sure, but a reasonable officer at the time, you train officers to take all these things. I mean, you just don't have that up there for no reason. You don't have a policy for no reason, right?
Correct.
They're trained to take these into consideration.
They are.
And so part of the training would say, hey, somebody's bigger, stronger, you got more people. It may not be the best idea to go after somebody in those situations, right?
Potentially.
Somebody is hitting a button or something with this feed.
Yeah.
I'm going to say, like, we can't put this on the board because we're still trying to keep
No
up with
chicken
that training
coop tour.
stuff. For the media, the jury will get this. Staying with Exhibit 32. This would be use of
I don't know what's going on here.
force policy changes from 2020. Do you recognize that?
I do.
And one of the policy changes
So that's the use of force policy from 2020. That's what I got out of the flickering.
was, well, maybe not a policy change, because it was a warning before shooting. That's one of the things that's listed there, correct?
Yeah, under number 3, it says require a warning before shooting. Then our MOP, which is our manual procedures, whenever reasonably possible, officers should provide verbal directives before deadly force is used.
Verbal directives for deadly force.
Warning, lefty.
You kind of said yesterday, that covers anything like stop, or it doesn't have to be stop or shoot. Stop is sufficient under your view.
We don't define exactly what a directive is, no, but stop could be construed. I would say can be construed as a directive, yes.
What's number 4 there?
Require that all alternatives be exhausted before shooting.
Okay.
Already, and then underneath it says already in manual procedures 9-1 under escalation and de-escalation of force.
So it says it's a kind of a change, but that's, according to that, you already had that. You're supposed to exhaust all alternatives before shooting, correct?
It says that as a use of force policy change, recommend yes.
So under policy, you're supposed to try and exhaust all alternatives, right?
Correct.
Okay. Now, I get it. Yesterday you said if somebody walks up, pulls a gun out, you don't have to try and do anything else. You got to respond with deadly force if you're met with immediate deadly force, right?
Yes.
But Grand Rapids Police teaches a number of different things in terms of use of force continuum, don't they?
I would say in use of force, we don't necessarily have a continuum, but yes.
But in terms of use of force, pressure points, right?
Correct.
Let me go through them.
This guy was fighting so bad. Why didn't you punch him in the face more?
Right between the neck here. This is a pressure point, if you will.
Yes.
So you train on these, on both sides, pressure points, you can get somebody like right here, correct?
Potentially, yes.
You jam it in and that's a pain compliance, guy. Is that a, please?
It's semantics the way you're describing it, but yes, it's more of a, you have to control the head, or so that way the person doesn't move away from your pressure. But yes, it's
There's that.
pressure in and towards the top of their head. Yes.
You have the hypoglossal.
Correct.
This is bad, I get. The hypoglossal is kind of grabbing them underneath the chin, like right underneath here, the jawline. Is that a fair?
Yes.
Okay, so you can grab them, manipulate them that way. That's a pressure point that you teach.
Yes.
You have infraorbital. I'm not going to do this to you, but that's kind of getting somebody from, you get them up under the nose and yank back on the nose.
Correct.
Why didn't he do any of this stuff, Captain?
Oh, excuse me. You have
That's
the
what I wanna
combination
know.
of the hypoglossal and infraorbital,
That's what they're gonna go
right?
for.
Yes.
You have the two, you have a under the nose and under the chin to yank somebody backwards, right?
Correct.
I could
We
do that,
have
Lefty.
the jugular notch. That's
Be a good
right
experiment
here.
for YouTube.
Is this correct right here?
Yes, in that region. Correct.
Is it you got like a little, when you feel your bone comes together, you got a hole right there. That's taut.
Yes.
You have the brachial plexus. There's a muscle, it's your shoulder muscles. That's a pressure point right along the neck. In this area, you can jam down on it, grab it.
Yeah, and it kind of feeds up to the side of your neck. Yes.
So that's a pressure point that could, once again, is that a pain compliance or does that?
It can cause both, like a motor dysfunction or pain compliance.
Okay, but that's something you teach.
Yes.
The clavicle notch. Okay, that would be right in here. Is that like between you, as a collarbone? Or
Mostly, yeah, roughly where your collarbone meets.
So there's like a hole between where it's kind of there's a almost like a hole. You can press down on that, right? You can press down here. Is that fair?
Yes.
So those are all pressure points that are taught.
Correct.
On top of that, then you have the takedown strikes and stuns, right?
Yes.
You have a brachial stun. It's like, okay, the brachial area, it's like a karate chop to the neck.
Can't chop. It's
Okay.
got to be a flat surface.
I'm sorry?
Can't. If a chop or a punch would be considered a deadly force option because of the risk of injury. It's a flat surface striking the side of your neck.
So like that, more than
Correct.
that.
Or back of your hand or inside of your forearm, something.
Actually, chop, people can collapse, get knocked out kind of from that, right?
It's potentially, yes.
Do you teach that all? I mean, in desperate situations, that like a chop is okay, or is it always flat?
I mean, potentially it could be an option if that's what, but we don't specifically train people to strike in the side of the neck as a deadly force option. No.
So we have a forearm strike. I think we saw them on the training. I don't know if you're in here, the forearm strike where you're punching with your forearms, right?
Right.
So that, I think, in this instance, did you see, I don't know, did the defendant do that in this instance? I was more open hands. Did he do it in forearm?
Didn't appear so. No.
I don't think the pepper spray would have been good.
Yeah, your palm
I think
heel
it
strike.
would have
That's
been
a punch with a
at that point.
heel, right? That.
Yes, the meaty part of your palm.
Then you have a straight punch, which is just your normal punch, straight punch, right?
Correct.
You have a combo, the palm heel strike and straight punch.
Yes.
So you do like a punch, heel, punch, you kind of alternate. Is that the idea?
Different arms, like using your body momentum. Yes.
There's an angle kick. What's an angle kick?
Striking one of the outside of the leg. There's nerve points there with your bony part of your shin, more or less.
And the officer did none of these. Isn't that
kick
right,
across
Captain?
somebody.
What's a shin kick? Would be a kick specifically right to the shins, right?
Yeah, it's more of a, if you think about stubbing your shin on something, that pain kind of down by your top of your shoe or boot. Yes.
And there's a knee strike. So we definitely saw him do a knee strike.
Correct.
So we did one of those things.
He did.
What's a straight arm bar takedown?
It's a takedown option that we teach and train where you extend somebody's arm down and the officer would be in this area and you use body momentum and mechanics to bring them down.
How about iron wrist takedown?
That would be if a handcuff is applied or partially applied, you use the body mechanics of your wrist bent and the mechanical advantage of the handcuff to pull somebody down.
So definitely that one wouldn't apply because it wasn't handcuffed. That's only using handcuff.
That's the iron part of it, yes.
Okay. What's a 4-finger wrist lock?
That would be more or less just bending the wrist and kind of a arm weave to bring somebody down.
How about a rear centric takedown? Because this is a big one. Because a rear centric takedown under your training, what I've seen is designed for even if somebody's bigger from you, you can kind of pull them down from behind.
If somebody decides.
Sorry, what was that?
the rear center takedown.
Yeah, I use that one every night.
That's a good title of an adult movie.
Different size. You'd have to break down their height disadvantage because it's again body mechanic.
I think they were pretty much the same height, weren't they?
The final one's
Maybe the
shock
officer was
control.
a
I
little
couldn't-
shorter.
Is this, you kind of grab somebody with the face and push them back? And
It's more of a cheek hold, and you have to again counterbalance, just like all of the pressure points, because the pressure, if you're not counterbalancing it, they're going to be able to escape that.
Okay. Now, do you have your asp on you?
I do.
Can you bring it out and show it to the jury?
I can.
Good
I
morning.
carried mine behind my firearm. It's expandable baton.
I want to see the
Can you expand it,
5-finger
please?
death punch.
It will expand to
In the
Zoom
old
in more,
eras, they had
This would be the impact. That would
in
be
the
an
old
impact
eras they
weapon we
used
talked
the
about
3-finger hold.
Okay. It's not just, okay, they got this swing away, right? You teach them on specific things on how to use that, right?
yes.
One of those things is open mode to common perineal. What exactly is that?
So as the officer opens that baton or expands it, striking the peroneal nerve runs on
But
the
none of this
outside your
means
thigh, kind of,
that the
I think, of
officer
seam of your
didn't
pants
have
or
the right to use the
gentleman
gun,
anyway.
right?
Yeah.
That's not
Yeah.
what this is saying.
These are alternatives, but
Above your
it's
knee, below your hip.
ultimately it is
What's the
in the
femoral
hands
strike
of
with the axe?
the cop.
The femoral
How
nerve
scared
runs
is he?
on
How
the
much
inside of your
control does he
thigh.
have?
Obviously, large artery
What
too.
grips
So that would
are
be the
physically
target.
possible?
You have a radial medial strike.
Nerves on the top of your forearm and the bottom of your forearm.
So you're trained specifically to strike with your asp on the top or bottom of the arm.
Correct.
And then we talked about it. OC spray is part of it.
Yes.
And there's a reason why the OC spray might be effective, but that's another option.
Yes.
We talked about a little bit, when those are kind of your traditional normal ones. Flashlight is kind of a trained thing. If things are going really bad, you let your officers use a flashlight to strike.
It could be used as an impact weapon as opposed to a baton. Yes.
Now, you talk all these training records, I kind of put them in front of you. These are all taught basically at the academy, right? Or not the academy, through your training program.
Correct.
When they're recruits. And so these training records, use of force, you're recertified each year, right?
Yes.
So these training records we have, the defendant was recertified every year on all these pressure points, ass strikes, whatever, any training that we just went over. He's recertified every year on that.
Correct.
And in fact, he was recertified on February 22nd, maybe a month and a half before this incident.
Yeah. I think so.
Yes, ash strike. That's a wrestling move. We are getting into WWF or WWE now, I guess.
They have been in the WWE since 1998.
One of the things you also talk
Yeah,
about
well, that's
is
about when
action
I
versus
stopped watching
reaction.
it.
That's something you train.
Correct.
When
So action versus
they
reaction.
were sued by
Yeah,
the
so
other WWE.
hypothetically, you're an expert, so hypothetically, you're responding to a
Or
domestic
WWF.
violence call. That's something.
Yeah, when they joined, that's when I started
Yes.
watching.
So you respond to a domestic violence call, they say, went out the back. You go out the back. I'm standing there with the gun. You can't shoot, you can't.
You're standing there with a
Just
gun.
standing there, right like this, gun at my side.
There's a lot of factors to it, but it would depend.
Well, what other factors?
Depends on kind of how you're moving, distance of us.
Just said, I'm standing. I'm standing here right there. I'm standing, gun pointed, I'm looking at you.
No, I wouldn't shoot in that situation.
Why not?
Because you're pointing at the ground.
Okay, not posing a threat to you right now, am I?
No, you're a threat.
I'm a threat, but I haven't done anything well, if I'm a threat, why can't you shoot me then?
Because I would have you at high ready, my gun pointed at you, giving you loud verbal commands.
Wonder if I'm running away.
I would be giving you loud verbal commands. So if you have a firearm in your hand, you're running from me, I would still have my gun up and giving you verbal commands I can chase.
But action beats reaction. I can quick shoot,
Yes.
right? That's what you're trained.
Yes,
That's
But
why you
even
have
in
your
this
gun up.
instance, this wasn't a gun, this was a taser, right?
it was.
Taser doesn't do the same thing as a gun. You would agree with me on that, wouldn't you?
Does not function like a firearm, no.
So the one big concern of the tasers is going to disable somebody to have somebody access their gun. That's one of the biggest concerns, right?
Yes.
Yes, everyone's agreed to that. An immobilized officer by his own taser is
You know
very
that you
dangerous
used
for the
gun
officer.
before this happened, correct?
Correct. He worked for me when I was on midnight as a watch commander.
So he was one of your staff, if you will.
Yes,
And were you part of his training as well?
I have been over the years, yes.
When the honky tonk man lost to the Minnesota governor. That was what?
That was some time ago.
I left with stone cold. When he retired, I retired.
But now you have, what's his name? The son of the Steiner, one of the Steiner brothers, is now in the.
It's on
in
like
the
every
roster.
night. I should watch it again. See if I can get back into it.
Yeah. Yeah, I think this. He's calling himself Braun Breaker.
Morning,
And
Captain Cyber.
He probably made the most violent spear ever seen on WWE just a couple of weeks ago. He sent that guy flying.
I just wanted to point out that was the end of the cross. The end of the cross was actually the captain giving very good testimony in favor of the defense. So this case keeps going back and forth. I'm at a loss. I'm still in the middle. I could still go either way. Now we're gonna have some boring redirect. I'm sorry. This attorney, she's got her list of questions. She's not gonna follow up on any of them. We'll see where this goes.
All right, I have a few questions for you. You were asked by Mr. Becker about your status as an expert for the defense, right?
Yes.
And were you ever asked by Mr. Becker to provide information about this case?
Only when Detective Sergeant Tubergen asked to meet with me, whatever, last week or 2 weeks ago.
And when he asked to meet with you a few weeks ago, did you meet with him?
I did voluntarily meet with him, yes.
And are you aware of anyone at the Grand Rapids Police Department that was asked for their opinion by Mr. Becker about this case?
I am not.
Are you aware that the prosecutor has had GRPD's policies and training since this incident occurred in 2022?
Yes.
Are you aware if anyone at GRPD was asked about the training and policies?
Just because it's redirect, it's not a cross exam.
Speaking of
I'm clarifying.
Okay, so before she responds, she should know that she's not leading. She's offering foundation, reaffirming the question that was asked on direct so that she can correct the testimony. So that's not leading. That's appropriate, but she's not going to do that. I guarantee it. She's going to be like, I'll just rephrase.
Find the information that Mr. Becker has put out there.
And you can clarify about asking leading questions. So
It's not a leading question, Judge. But
you can just rephrase.
it's a bad
Has
way of
Mr.
doing
Becker
cross.
ever
but
asked you
it's
about
not leading.
GRPD training or policies prior to a few weeks ago?
Before yesterday, no.
And how much are you getting paid to be an expert for the defense?
I am not.
Were you ever asked to provide a written report like the paid experts in this case prepared?
I have not.
And you met with Detective Tubergen? Did you meet with?
Wait a minute. Objection assumes facts, not evidence. Nobody asked about how those experts were getting paid, if they were getting paid or anything. We addressed that the last couple of days. They never asked that. That assumes facts, not evidence. Where's the objection?
Detective Tubergen before this case?
No, the day of the incident, I don't believe Detective Tubergen was present for the round count. I believe it was one of his colleagues.
Sorry, did you meet with Detective Tubergen before the trial?
No. I'm sorry, the 23rd, I think the date we sat down in my office for an interview, or whatever that date was, recently.
And when you talked to him, did you discuss the nature of your testimony with him?
No.
When you met with Detective Tubergen on April 3rd or whatever it was, did you discuss some of the GRPD policies and training with him?
Just the specific questions he asked in regard to if we had a foot pursuit policy and then the taser related, I forget the verbiage in the report there, but about the taser disarming or whatever.
And you provided answers to all of the questions he asked you, right?
I did.
And you were asked some questions about GRPD's policies and trainings about foot pursuits.
I was.
And you helped identify some of the mandatory trainings that GRPD has about foot pursuits, right?
Correct.
And they included the different training scenarios that you train Grand Rapids police officers about foot pursuits?
Yes.
Okay. And those are all within the records provided to the prosecution, right?
I would assume I'm not the records management area of the department, but I would assume so, yes.
Your Honor, do I have permission to approach?
Yes, and with
This is what has been marked as Defendant's Exhibit II.
I'm gonna build some Lego while I'm doing this. I got these from Wendy, and I haven't built them
Captain
yet.
Sever, do you recognize this document?
I do, yes.
And is this a summary of the GRPD policies and training?
Yes, it is. It's a policies and mandatory training summary chart.
And there are quite a few mandatory trainings that have been provided at this point, right?
Yes, it chronologically starts from when Officer Schurr was hired in 2015, and then chronologically through
Oh, she's so boring.
2022.
And this, and I guess if we need to bring all of that, but is it fair to say that this is Exhibit F? This includes some of the pages from that mandatory training, but there are binders worth of training that
Yes.
received, right?
Yes.
And Your Honor, the defense would move to admit Defendant's Exhibit II at this time.
Is this something that's part of GRPD policies?
This is a summary of policies.
That's what I mean. The summary is not in the GRPD policies, right?
I'm not sure I understand your question, sir.
This is like when you go into your policy manual, this is not a document. This is not a document created by GRPD, is it?
This is not a document created by GRPD, no.
Who created this document?
I don't know.
You don't know who created this document, so how do you know what it is or where it came from?
I just said I don't know where it came from. I understand the verbiage and the exact quotations that are taken from several of these mandatory training files.
So, but this is not something that's part of the actual policy. If you don't know where it came from, so I don't believe it's admissible. There's not a sufficient foundation.
Your Honor, if you'd like, I will go through the mandatory trainings then. Mr.
Sorry, but, so.
I mean, we-
withdrawing your move to admit, or are you going to have something else you'd like to-
She gives up too easy. She's very inexperienced. He can still lay a foundation if he's familiar with them.
We'll withdraw the summary chart. And at this time, we'll,
Refer to the training, like you held up a book, was that Exhibit F?
yeah, that was Exhibit E and F. But
But then-
I was referencing Exhibit F, yes, that, which is already,
1 through 18?
yes,
So that's already been exhibited.
yes. And I guess, Bob, if you can actually, before you publish it on the screen, can you please pull up the People's Exhibit 31 and go to page 15? Or just go straight to 15? And Your Honor, may I approach?
Yes.
Is this a document or is this a video?
I'm handing Captain Stiver with what's been previously marked and admitted as the People's Exhibit 31. And Bob, can you go to,
Look at the little duckies coming along, or the little chicken. Now what? This officer, this captain, he's a little stressed out. I think he knows this isn't going well, and I think he's concerned.
4 of our coverage of courthouses taking bench start.
Okay, I don't need your commentary.
This is the nature of what will be displayed on the screen. I'm instructing media to not shoot the screen. And the witness is okay, testimony is okay, but showing what's on the screen would need to be, will not happen.
Wait,
And go ahead, Ms. Hamilton, your question about, you have page 15, and you handed him page 15, right?
I believe it was, actually, it might be page 14.
so she's trying to introduce a document. We don't know what it is yet.
What is your exhibit?
I'm not sure what's going on.
No. It seems like the defense is trying to introduce another piece of new evidence that haven't been disclosed.
It's been disclosed, I think. They don't have to disclose it if its purpose is rebuttal. They don't have to disclose it ahead of time.
All right, sorry, Bob. I don't know exactly what page this is in the People's Exhibit, but this is the same as Defense Exhibit F5. Can you pull that one up, please?
Oh, so this is something that's already been admitted.
Yes, which has already been admitted.
Well, that would take care of it.
Yeah.
It's the same, yeah, it's the same. I just don't know in the People's Exhibit which page it is. And I just used the relevant pages in ours. Okay. And directing your attention to the scenario 1, discussing the foot pursuit. And as part of your, can you explain what this type of scenario is and what it includes?
Yes. So oftentimes in our mandatory training cycles, we have specific objectives or training goals. So, for example, this is 1901, meaning it was 2019. It was the first training cycle of the year. So CEW, ECD, taser. We're trying to accomplish a specific objective with scenario 1. So many times we build out scenarios that are very scripted, so we could try to limit for safety reasons and
Well, they're on
to get the response.
witness number 5, potentially.
This scenario 1 was
Brandon.
we set up that the officer is responding to a foot pursuit that another officer called out, and when they arrive, they find the role player, which is acting as the assailant or the suspect, is on top of the officer. So to get a close probe deployment, meaning firing the taser from a close distance with a follow-up, touching the taser to a different point in that body to achieve the electrical circuit or NMI.
And that involved an officer who was
We're right
also
on time,
in a
Salvador.
solo foot pursuit?
Correct.
And you trained Grand Rapids police officers, including Officer Schurr, on solo foot pursuits, is that correct?
Correct.
Bob, can you please pull up Exhibit F17?
Bob.
Your Honor,
We've
do I have
heard that so
permission to
much.
approach?
Bob, pull it up.
Say what you're approaching with.
I am approaching with Defendant's Exhibit F16, which has already been admitted into evidence.
Thank you.
Okay, I'm now handing
Look at the little
Beth and
chip
Cyber
coming along.
a copy of their unknown risk traffic stop training. And you were asked some questions about unknown risk traffic stops. And Mr. Becker had questioned you about an officer's ability to leave the vehicle. Can you talk about some of the factors that you train officers to look for, which are reflected on page 2 of the PowerPoint? There.
Yes, sorry. So as the jury
The
can see,
witness was falling asleep.
just working through things to think about, things to be aware of. What's the nature of the offense? As in, why are you stopping the vehicle? We have what we refer to the only 2 variations: unknown risk and high risk traffic stops. High risk would be a known violent crime has been committed. It's a vehicle that matches the description. There's specific intent, or specific information that leads you down that path, and you have time and resources and all that. Unknown risk is what this incident would be classified as. So understanding why you stopped the vehicle, environmental hazards, meaning, where do you stop the vehicle is geographically or location, any
Wait, Lowe's
intelligence
is
that's
using my
available,
music
type
now?
of vehicle. Obviously, like large vans and certain things like that are more dangerous because you can't see inside of them, or if windows are completely tinted and those kind of factors.
And is that all sorry,
Yes, that was it, sir.
okay. And is this all based on, is this part of the officer's discretion to
Yes.
determine? And is it usually, do you usually train officers to look for these threat assessments and analyze the person that's directly potentially posing a threat.
It's a very hard question for her to
kind
get
of
out.
a concept we talk about is handling one problem at a time, meaning an individual that's out of the car is your first priority. Right? You've got to address that right away, and then work to occupants in the vehicle if be. We specifically train our people to do a quick assessment if they're running by a car, where they'll glance or look and obvious signs of danger. But yes, they have to process all that information.
And in this case, who was the person that was presenting the most risk to Officer Schurr at the time of the stop?
As the time of
Well, let's give a little bit of a recap here. So Officer Schurr pulled the car over, initiated a traffic stop because it had wrong plates on it. It was for like a red Ford Focus or something, and it was a silver Nissan. Now, the testimony was that at the same moment, the Lyoya was pulling the car over himself because it was making a bunch of noise and he was getting out. As soon as Officer Schurr activated his lights, Lyoya got out of the vehicle. Officer Schurr yelled at him to get back in. Then Officer Schurr closed up, walked right up to Lyoya, who was standing just outside of his vehicle, and said, give me your ID, and then asked if he speaks English, and the guy said yes. Officer Lyoya then tried to detain him, or Officer Schurr tried to detain him. Then Lyoya, the victim, the driver, pushed him away, fought with him a little bit, ran, was tackled. They struggled. The officer pulled out the taser to try to tase him while having one hand on Lyoya. Then the Lyoya grabbed the taser. They fought over the taser for about 2.5 minutes. They ended up in a position like this on my thumbnail anyways. Oh, I don't even have it up anymore. But so the suspect ended up on his stomach holding the taser, the officer on his back. The officer says that he was fear of great bodily harm or death because the suspect had the taser and then shot him in the back of the head. So the officer is claiming self-defense. This is the defense's case in chief. This is the captain of the Grand Rapids Police Department who's testifying that everything that Officer Schurr did was appropriate within procedures. And that's what they're going over now. So hopefully that makes sense.
It's time to stop the driver was.
Why?
Because he was already out of the vehicle. He had separated from the vehicle. Officer Schurr is still trying to get his radio traffic out, put the vehicle in park, undo his seatbelt if he had it on, and get out of the vehicle.
Bob, could you please go to page 14?
He would, yeah. I mean, but here's the thing is that the officer doesn't know he's drunk at the time, although maybe he smells intoxicants. Maybe the guy's slurring his words and he has suspicion. He doesn't know that Lyoya at 8 a.m. is at a 0.29 or 0.28 blood alcohol content and has been for many hours, including the night before, and was driving around after buying some beers with his buddies with open intox. He doesn't know that. He doesn't also know that Lyoya has domestic violence past and that there's potential outstanding warrants.
Yeah, he doesn't know. The cop doesn't know anything about anybody in the car.
Yeah, he doesn't know anything about any of that. I don't even know if the officer, well, he's got to know that there was a passenger because Lyoya at one point asked the passenger to open the glove box to get his ID. The passenger opens it and says there's no ID. And then that's when Officer Schurr says, okay, I'm going to detain you. So, and that's when the scuffle, the tussle as the neighbor would describe, ensued. So this is the case. Now, the video looks really bad. We've seen the video, and I say, based on the video, I don't know. I'm going to need to hear from the officer, and I'm very pro defense. So you're innocent unless the state bends over backwards to prove you guilty, and then they play the video, and I'm like, okay, he's guilty. So unless I hear from the officer, I don't know.
The last half second of that video shows a type of intent. I'm going to kill this guy.
Yeah.
And not necessarily self-defense.
Yeah.
So.
Yep. So that's where we're at.
Let's go. And
Not
one of the things that we
building
talked
Lego.
about a little bit yesterday is how you train officers to assess people's risks or the risk that someone poses. Is that
Yes.
correct? And what are one of those concepts that you train them?
No, nothing but.
I think we said it yesterday, but if it didn't, historically, most foot pursuits end with a tackle or they give up. It doesn't usually lead down a long, drawn out, extended struggle or fight with the suspect. So the concept you see on the slide, failure to comply, ask yourself why. What am I missing? What do I not know? Why is this person fighting so hard?
Yeah, it's a
to not
legitimate
Be
question.
put in handcuffs or be arrested. So you, again, the action versus reaction. I don't know why. I can't be in their mind. I don't know what they did. I don't know. I obviously know I had an arrest, or specifically if I have an arrest, and why they're fleeing and why they're fighting me so hard.
Bob, can we pull up Defendant's Exhibit E1,
Bob.
please?
Bob, we need Bob again.
And this is the GRPD use of force policy that we spoke about
I
yesterday
am
and that
right
you were
there
asking
with you,
questions about.
PG.
Yes.
And you,
Yeah, this is
Mr. Becker was
very
asking you
long.
some questions about OC spray. And Bob, can you go to 9-1.3?
Bob.
So on page 3. And then
Was the guy
2.
really outside of his house? I don't think they have testified to that yet.
And what is OC spray
wasn't-
considered?
It wasn't his house. I thought it was this whole time, but it turned out not to be because apparently Lyoya lived in an apartment somewhere, at least according to the passenger. Lived in an apartment somewhere. And obviously that's not an apartment, that's a house. So
Under our policy, it's under 2, subparagraph B, compliance controls, which lists out soft empty hand techniques, meaning joint locks, wrist locks, pressure points, and then compliance control devices, meaning handcuffs. ASR stands for aerial. It's OC spray.
why didn't he
And that's
pepper spray
OC
him as well
spray
as
is similar
himself?
to pressure points.
Correct. It's one of our lower levels of force options available.
And Bob, if you
With-
could go to
with
the
what
next page,
hand
which is
should I reach?
9-1.4.
Then he had to give up the taser.
Right.
Yeah. So with what hand?
But this chat, yeah, the passenger who called him his bro, but didn't know his last name, didn't know where he worked, didn't know what he did for a living, didn't know where he came from, but he's my brother. He's like a brother to me, man. Oh yeah, and didn't know. I don't even think he knew. Yeah, he didn't know his last name. He called him Pimp. That was his nickname. Pimp.
D. What is a taser considered?
That would be an intermediate level of force, along with impact weapon, the baton.
But see, that's what the state's going for, Brandon. What he should have done, right? In hindsight. And I think the legal standard is, was the officer lawfully performing his duty? Did he violate a law? And was he in fear of imminent great bodily harm or death? That's the only issue, not what he could have done different. But was he acting lawfully, which none of the testimony from the state said he was acting unlawfully, just that he might have violated procedure. And was he in imminent fear of great bodily harm or death?
Those type of things.
And that's is that a higher level
I
of
don't know if
force
he was a
than
drug
OC
dealer.
spray?
Yes.
And once a person tries to disarm an officer of his taser, and they have been fighting over it for over 2.5 minutes, and once the officer makes a
He didn't say
decision
bro, he
or is
said
in fear
brother.
of serious bodily injury, is he entitled to use deadly force?
If the situation is there, yes.
And once the officer makes the decision to use deadly force, is he required to go back down and try every lower level of force?
No,
Why not?
because it's not reasonable. We keep saying that term, reasonable. It's not reasonable to expect if I've exhausted other options of force in my escalation and they've been unsuccessful.
I don't think this cop should
how
be a
could we
cop.
possibly expect him to go back
I think
down
he's
that ladder?
kind of guilty of at least
They
manslaughter.
demonstrated that it's
I don't
been
think he should have had to do it.
for a myriad of
But I'm willing
reasons.
to be
But it's been
convinced if he
ineffective.
takes
Why
the
can't
stand.
they go? why should they have to go back to lower levels of force?
Are you aware of the Kent County Prosecutor's Office ever charging a defendant with resisting and obstructing after a foot chase?
I am, yes.
And did the office take the position that the defendant should be let go because the officer created a dangerous situation?
No.
Are you aware of the Kent County Prosecutor's Office deeming that running away?
I'm gonna have to object. This is what the relevance is on every other case that we've charged. We charge thousands of these, and so I don't see what the relevance is on what our decisions are in some unknown cases.
Your Honor, that's a position that this office has taken, that the Kent County Prosecutor's Office has taken previously. They've charged people for resisting and obstructing for
Doesn't even
foot
matter
pursuits.
what the
And the
answer is.
officers
It
have
got out in
engaged
front
in
of the
foot
jury.
pursuits to
All this is in front of
catch
the jury.
the person.
The other cases. So I'll sustain based on relevance.
That just got out in front of the jury. Nobody could
He was
test.
asking about the foot pursuit policy and whether it's permitted or if there is one.
But you're asking about a different policy of a different office.
Well, I'm asking if it's a crime to run away from the police and if,
Is that what you're asking?
I mean, no, but I'm asking if it's a
Yeah, so I'm sustaining the objection on the basis.
Well, ask that. Is it a crime to run away from the police? So I think she accidentally stumbled backwards into getting the question out in front of the jury and making the point she wanted to make. She didn't do it on purpose. That's clear. But she at least got the point out in front of the jury. So, well, this one I'm okay with because I know what she was trying to get at, and I'm fine with it. You know, like you guys charge people all the time for doing the exact same thing that Lyoya did, right? So I'm kind of okay with it. But yeah, the speaking objections, I mean, if you know that they're there, then you use them to your advantage. She did it accidentally, but I think it's still going to work.
one moment, Your Honor.
Building my Lego. I am extremely disappointed in the quality of the defense. I don't like to see bad defense work.
Yeah, it seems like she's stumbling upon good arguments by mistake.
All right, no further questions.
That's it.
Yep.
All right. Oh, we got jury questions. I don't know if he was there legally. He did not have a driver's license. But again, none of that matters because the officer didn't know it at the time. All the officer knows is that someone got out of the vehicle and was not compliant from the get-go. And then ran, and then fought, and then continued to fight, and then grabbed the taser, and then wouldn't let it go, and then continued to fight. That's what the officer knows. So I don't fault the officer for anything up until he actually took out his service weapon. I don't even fault him for that. My thought would be, if I'm going to look at it like Brandon, like Let's Go is that when he took out the service weapon, he should have stepped back a few feet, trained the weapon on the suspect, and then if the suspect stood up and started coming at him, it would have been a much cleaner self-defense argument. That's my thought. But again, it's hindsight. And I would really like to hear from the officer himself to explain why he felt it necessary to shoot in that position. That's my biggest thought process here. Let me see if I can pull this up. Yeah, so today is day 4, right? All right, so let me pull up the thumbnail while we're on a second of a break here. And I could show you the position. That's the position that they're in. This is just after the shot was fired. Right now, supposedly the taser is in the right hand of the suspect and could potentially have been used against the officer. This just looks bad. So I want to know from the officer why he felt it necessary, you know, because no one can see what's going on the right side of these bodies. All the camera angles, all the witnesses were on the left side. the side that we're looking at. So that's my thought. What's with Michigan unlicensed driver on the road? I have no idea. Probably because we don't need vehicle inspections. So you get a vehicle, you just drive it. I know an attorney. Yeah. But not on this witness in this case. I agree. Yeah. I don't think this is where she needs to gain her experience. I also feel, and I got to look into this, and I haven't looked yet. I haven't looked at the name of the attorneys that represented the defendant in the appellate at the Court of Appeals. If they're the same attorneys, that makes sense because these are very technical attorneys. But that's not the type of attorney you need for a trial. You want a showman. You don't want a technical attorney. Stop showing us this as if it's... I'm just trying to give you guys an example. I'm not going to play the whole video. I have other videos where Nick and I have broken down all of the videos. You guys can go watch there. I'm telling you why I feel my feelings.
In real time.
In like the average training scenario, I'm
I
assuming?
guess the context is that we saw the graduation video, for example, that showed a clip.
Yeah, so for...
But how long is the actual training simulation?
Yes, Your Honor. So the example, that graduation video that had Officer Schurr's a snippet of his time, those OC where we expose them and have them do drills, that's probably roughly a minute and a half to 2 minutes by the time they work through it. There'll be usually multiple dummies or stations or areas they have to complete exercises at. So, for example, that one's probably 2 minutes.
And the next is how often are those simulations required during training?
So the exposure happens while they're new hires, right? Sometimes historically, if you go to become an instructor in that area, you get exposed or sprayed again or multiple times, or if you recertify in that. But for the average officer that isn't an instructor that just participates in our training cycle, they don't get exposed to taser and pepper spray, but they do reality-based scenarios multiple times through the year on a yearly basis.
Next is, in your opinion, since we're in Grand Rapids, are the GRPD DRPD policies and procedures meant to supersede the generally accepted police policies and procedures?
So that term, I know you've heard it a lot. It can be construed some ways. So our policies and procedures, our training calendars, those the training calendar isn't published publicly, but our policies are publicly published. We are CALIA certified. CALIA is an international organization that accredits agencies. So they do a full review from top to bottom: training, policies, equipment. And I have to submit yearly reports based upon reviews. So they're a 5-year cycle that you're certified for the accreditation. We've been accredited since 2017, which puts us in the top 5% of all agencies in the United States, at least, for that. And then we've also had 2017, I believe it was, the 21st Century Policing. They came in, they did multiple work group meetings with community members, and all that, department members, all that, and reviewed our policies. I think Mr. Becker brought up the exhibit had something from that 21st Century Policing recommendations. So we've had multiple reviews by accredited, national agencies or international accreditation agencies.
Yeah, I don't like the video.
They're not meant to supersede.
Why? Okay, this is so inappropriate. The judge is supposed to ask the jury question the way it was written. And if the witness can't understand the question or can't answer it, that's fine. The judge should not be asking questions. The judge should not be asking clarifying questions or anything. The judge is not the fact finder. She's done this multiple times. on her own, even without jury questions, and that's highly inappropriate.
Correct. And I think my point with that is those accreditation agencies wouldn't accredit you if your policies were out of norm. So, and again, policies that may, for example, say the Los Angeles Police Department may have a policy, may have a foot pursuit policy. What happens in Los Angeles doesn't equate to Grand Rapids or doesn't make sense. So we pay attention to regional things much closer than on the national stage because use of force laws are different in the state.
That's a
Florida,
shot at
South
those
Carolina.
experts that testified yesterday.
Practices
Or
are
the
different,
last 2
right?
days.
Weather dependent, all these factors. So we have a ton of outside reviews. We've been accredited and reviewed and appraised by these organizations for our willingness to do that and open the doors more or less.
Do you have any follow-up from those responses?
Just a few.
This judge is she's got her whole
So,
career.
just to clarify, I think what you're saying here is that GRPD, even though some of those things are factors that are sometimes considered, GRPD policies supersede the national generally accepted police practices as far as what your officers.
Actually, that is not what he said.
Can,
If you could, I'm going to sustain that because it's not what his response is. And if you could just rephrase your question.
can you
She shouldn't have
clarify
asked any questions.
what
That's her question.
governs how you evaluate GRPD's police officers' use of force? Whose
By
policies and
our policies,
procedures?
and I would offer our policies do coincide with generally accepted police practices.
And when you say that term,
So
can
he
you
answered the
define
question
what you
anyways.
mean?
I like that.
That's a very broad term. So what do you mean by that?
Yes, I would point back to the reviews we have by the CALIA, for example, the international organization. They would not offer accreditation to agencies that policies were outside of the norm or generally accepted police
fun
practices.
size. I think Bronco came on with us last week, and from a technical standpoint, Bronco's like, yeah, this is self-defense all day long. If the officer was in fear for great bodily harm and or death at that time, knowing that the suspect had control of the taser. I still think we need to establish that the suspect had control of the taser at that time and that he was attempting to use it or at least in a position to use it because you need the opportunity to use it, right?
Yeah. Yeah.
Nick, have you heard anything to support that?
Yeah, and even Branko said on his summary yesterday that, both parties are putting forward a bad case, which is bad for the defendant.
It really is.
Right. I guess what standards are you evaluating GRPD's officers by? When you're conducting like a use of force evaluation, what do you look at? Within
One
GRPD?
policy, the training that is consistent with training, obviously state and federal law, which our policies are derived from.
And it's GRPD's policies that are governing what the officer or how you're evaluating a GRPD officer's conduct, right?
Yes.
Like the prosecutor's just fuming over there at the other table. I wish I could watch him.
One moment, Your Honor.
You're done. Just sit down. Just sit down, lady. You've done enough damage. Sit down. So it's a probing taser. Two of the probes had been fired, or two shots. The only two shots had been fired. It's questionable whether or not the officer knew both of them had been fired, because I think the second one was accidental by Lyoya.
I got the other question in terms of the length of your training. You talked about the training with the exposure to the OC spray that we saw in the recruit. I guess generally, how long are your dynamic training situations when you do those after they become officers?
Sure. Just an average scenario could be anywhere from 30 seconds to several minutes. It depends on what the intent of the scenario is. But it's also, I want to clarify, it's difficult to recreate physically exhausting scenarios for the risk of injury to the officer and role players.
Yep. Thank you.
And I think you touched on this a little yesterday. When you're doing the scenario-based training, like the videos you talked about, when the officers are actually fighting with another person, how long are those scenarios?
Those we specifically designed for, depending on the officer's physical ability or fitness level, 30 seconds to a minute and a half, depending on, because the risk of injury skyrockets when people are exhausted and that. So usually we can accomplish what we need to demonstrate that, usually within 30 seconds to a minute and a half.
Yes.
Any other questions? I do see one hand on the jury, so I'll ask my
Nope, we have another officer coming up.
I would assume it's a colleague to the defendant.
Yeah. So someone had asked if this was the Attorney General's office or the county attorney, county prosecutor. I think it's the county prosecutor.
Yeah, I think so too.
Yeah. And so the relationship has got to be a little tense.
Yeah, I mean, these are cops they want to use in future cases.
Mm-hmm. Yeah.
And
for
unless
the
you have a
prosecutor,
really, really strong case. But, I mean...
for the prosecutor to come off so angry against this captain, who I guarantee he's going to call as a friendly witness at some point down the road, is amazing to me.
Yeah.
It's like they're doing a little sidebar. It's another jury question.
In your opinion, is deadly force appropriate in situations of active resistance or only in situations of active aggression?
That's a good question. I like that question.
Active resistance, you can't say always, but would most likely not lead to a deadly force incident. Becomes, that it's a fine line between resistance and aggression. So, for example, grabbing a taser would be an aggressive act, and that would raise the
for example,
level
in
of
this
force
exact
greatly.
situation.
Hopefully that answers it.
Okay, so is there a policy or training?
That wasn't the question, Judge.
The appropriateness of deadly force in active resistance or active aggression?
Yes, in our reality-based scenarios, we'll create that position so there's different force options and they understand the difference.
I
of
hope that
active
was a
resistance
jury
versus
question
active
written down.
aggression. And that's the whole
the
purpose
judge.
of why we train the way we do, so they have a conditioned response to those.
Anything follow up to that?
No, Your Honor.
No. Good. Sit down.
No further questions, Your Honor.
I don't see any other hands
The
raised.
judge is a lot of out of line.
No, Your Honor.
All right.
Oh, I'm sorry. These were my.
Yes, sir.
Thank you very much.
All right. We got
Thank you, Your Honor.
witness number 6 coming up.
Yep. Let's see who of his colleagues are going up to the stand this time.
Another police officer.
Yeah, but the department did fire Schurr as a cop. And here, all of a sudden, they have the precinct standing up for Schurr. So the
Well,
the relationship between the department and the precinct might also be a bit icy.
I would say that you notice they didn't call the police commissioner as the captain that was over his squad.
That might be the rebuttal case for the prosecution to call the commissioner. Now that is a good-sized cop.
I do.
He got exhausted after he took his first step towards the suspect.
Good morning, sir.
Good morning.
Sir, can you please state your name and spell your last name for the record?
My name is Chad McCursey. My last name
Of
is
course
spelled
his name is Chad.
McKersie.
And sir, how are you employed?
I am a police captain with the Grand Rapids Police Department.
All right, so Captain McCursey, correct?
Captain McCursey, correct.
All right, and how long have you
Another
been
captain.
employed with the Grand Rapids Police Department?
I've been employed as a police officer since the January of 2000, so over 25 years now.
And could you just give me a brief synopsis of your experiences and positions over the years, please?
Certainly. I first started as an intern at the Grand Rapids Police Department in mid-90s. Then I got my college education, returned,
This
and
cameraman.
was hired as a patrol
Got the
officer
name.
in
You
January.
got the
of
name
2000.
already. He said it.
I worked the road patrol for about 3 years, in the south, mainly in the South Service area. I then joined what we call the SRT, the Special Response Team, or the SWAT team. As a police officer, I did that for approximately 6 years.
No, I don't taste
I left the
suspect.
SWAT
I just
team, went
shoot
back
at
to the
them.
road. I was chosen to become a community police officer. Joined the community policing team for about a year, and then I was
Not
promoted
chasing
to
no
sergeant.
suspect.
After I was a sergeant, I went back to night shift patrol as a night shift sergeant on the road. Did that for just a few months before I returned back into the SRT as a sergeant and team leader in the SWAT team. Did that for approximately 2.5, 3 years. In that time, I left and went into the detective unit. I became a detective sergeant, overseeing our general case team for about a year, and then moved into our family services team as a sergeant and ran that. Family services handles domestic violence, sex crimes.
That's what I thought. It was the King County prosecutor.
Things of those nature. After that, I did a couple years there. I was promoted to lieutenant, and what we then joined, went back to the road as the watch commander. Our watch commanders or lieutenants run our road patrol shifts for the night and for the day during that. Was there for about a year and a half, then moved into our internal affairs unit. Was the commander of our internal affairs for
internal affairs. Okay.
16, 17
Get
months
behind that.
for the department. And then an opening became available in the training unit. At that time, the training unit was commanded by a lieutenant. I was at that rank. I took that position and ran our training unit for about 2.5 years. From there, I was then promoted to captain, and I moved to the West Service area as the captain of that team for year and a half again. And then another opening came in
the
support
college
services.
kid that films the
I
basketball
moved into support
games.
services. Support services
the high school
captain
kid that films the
handles
basketball games.
a lot of the admin work, a lot of the IT, buying the equipment, getting the cars, and a lot of paperwork just to get all the stuff that supports our officers out on the street with the equipment that they need. From there, I then last September,
Okay, we skipped.
almost 20 years maybe.
Now, as a master taser instructor, how many master and taser instructors does the department have at one time?
Typically one. At times we have two. We try to get someone certified as a master taser instructor and then have someone go the next year. So we have an overlap because the master taser certification only lasts 2 years. So we want to have a master taser instructor in-house so that certification doesn't lapse at that time.
How do you obtain this classification as master taser instructor? What were the requirements to earn that role?
To become a master taser instructor, you have to attend the training through Axon. Axon's the company that designs and created the taser. So you go to a 40-week, 5-day class wherever it's held. Mine was held in Los Angeles. You go to that facility, go through the training for its classroom test, a lot of practical exercises, designing stuff. We also teach you how to become a better instructor while you're there when you're doing it.
And upon conclusion of that course and in earning the role as master taser instructor, what do you do then when you go back to your
This
department?
name sounds so stupid.
With that classification inside the Grand Rapids Police Department, I train taser instructors for the department. And then those taser instructors instruct the officers in the classroom environment how to properly use the weapon on their belt.
Haven't we heard all
Now-
this already?
Yeah, I thought he was going to be in internal affairs.
Sir,
That's what I
did
got
you mention
excited
you've
for.
also been, is it commander of the Internal Affairs Division for a year or two?
Yes.
Taser face!
You have a significant amount of familiarity with GRPD training and overall use of force policies and practices that were in place on or prior to April 4 of 2022.
I do.
And do you have a significant amount of familiarity with GRPD taser instruction and practices on and prior to April 4, 2022?
I do.
And at this time, I would move to have Captain McCursey recognized as an expert in a couple of things: GRPD training, policies, practices with regards to the taser device.
This attorney is already
And
so much better than that woman.
Training, policies, and practices of GRPD.
I mean, it's still
related
kind of
to
boring,
use
but
of force.
I feel like he knows what he's talking about.
No objection.
All right, so he shall be considered an expert in those fields.
And when I say use of force, in just the general overall policies of GRPD related.
Yes, sir.
To the general duties as far as automobile stops and
Oh my
the
God, he's
basic
qualified. Move on.
performance and policies. in
Why
police.
are you limiting what
Yes, sir.
your expert was just qualified to talk about?
Expert in training policies and practices regarding.
Yep.
Taser, use of force, and then also just general overall police duties, police functions within the Grand Rapids Police Department.
Is this going to be 30 of these,
Any objection to that?
the local cop
No, Your Honor.
proffered as experts about tasers and general use of force?
I don't know. I was
So
thinking.
I'd like to
internal
ask you
affairs
some
would be
questions
cool.
related in particular to the taser. We had another witness who testified about several topics. I'm going to try not to go into a lot of the same things all over again, okay? But just to get into
Oh, thank you.
a few areas in particular related to taser, and then
He's
ultimately
he's
get
called
some
to
specific
impeach
questions about
Guy
the case
Smiley,
here.
our taser expert.
Now,
Who I liked, and I thought he was
the
fine.
defense
Yeah.
is calling you in this case to testify, is that right?
That is correct.
And has the defense talked to you several times over the last 3 years?
Yes.
And has the defense asked you a significant amount of questions about GRPD policies, trainings, and just the general practices of GRPD?
Yes, sir.
Now, did you also testify on matters related to this case about 2.5 years ago?
Yeah, I testified in the original preliminary examination for this case.
Okay, and were you under oath at that preliminary examination?
I was.
Now, have you ever prepared a report, a final conclusion report or anything for either party?
I have not.
Were you ever asked to?
No.
You testified 2.5 years ago, and was the prosecutor present for that?
Yes.
And
Oh, maybe this is the
has the
captain that I
prosecutor
heard
or
testifying.
detective on this case ever reached out to you and
The
asked
prelim.
you for more explanation on any training policies or just general overall practices of GRPD?
No.
If they would you have been happy to talk to them?
Yes.
He's getting out
Your
ahead of the
office
cross.
is about a block away from their office. Is that fair to say?
That is correct.
I like this. I like this preemptive cross.
Going to
or
the taser,
preemptive
what
redirect.
model of taser did GRPD use on April 4, 2022?
At that time, we were using the model Taser 7, the T7.
And where would an officer on duty on that date, where would they carry that device?
We mandate they carry it on the opposite side as their firearm, so you have to do a cross draw to pull that, access that weapon off of their belt at that time. The main reason for that is we don't want ever under stress to think you're pulling your taser and you actually pull your firearm. Firearm's on your dominant side if you're right-handed or left-handed. So we just mandate it's on the opposite side, so you have to make a distinct motion to go get that device to use it at that time.
Now, besides the taser on that belt, what else is an officer wearing when they go out on a shift for GRPD for the most part?
On their
utility belt, if you will.
This
What
is
they
still
wear
very
is obviously
tedious,
you have
though.
your handgun that's in a holster. You have 2 extra mags of ammunition on your belt. You have OC or pepper spray on your belt. There's an ASP baton, 1 or
An ASP
if not
baton.
2
See, I
sets of
told you.
handcuffs on your
You got
belt,
to ask strike.
your radio, as well as your taser device.
And then how about, you may have mentioned this, vest, do you wear a vest?
Yeah, every officer on the road is mandated to wear their bulletproof vest underneath their uniform. In today's world, you see a lot of exterior vests. This is the uniform that Officer Schurr was wearing was like this. So that is how we're equipped.
When you add up all of that equipment, approximately what weight, if you know off the top?
It's roughly around 20 pounds, 25 pounds. Obviously, my vest and belt.
I can tell you, I can move a lot easier now that I lost 20 pounds. I know the significant difference.
Now we
that
talked
20
about
pounds makes.
going back to the Taser 7. The manufacturer, Axon, they make other models as well. Is that fair to say?
That is.
And sir, did you have the opportunity to sit through the testimony of prosecution's expert, Mr. Bloomfield?
Half of it.
Okay. And did you sit through the testimony of the prosecution's expert witness, the law professor?
Yes.
Okay. Did you hear some of their opinions related to this case?
I have.
Did you have an opportunity to read their report?
I have.
Sir,
How do you find their
that they
report?
may have been referring to an
bullshit.
older Taser model than the Taser 7 in some of their opinions?
Yeah, it was testified to as well as in the report of, in one portion, they considered the optimal distance of 7 feet standoff. So it was documented in the report between 7 and 15 feet. That is the rule that was in place for older model tasers, not the Taser 7.
And we'll get into some, but were there some differences, the Taser 7 that Officer Schurr was carrying compared to the older models?
Yes.
Okay. So going forward in the testimony, Officer Schurr had a Taser 7. If I refer to Taser, can we just agree we're talking about the Taser 7 unless I say something different?
Understood.
Now, under the GRPD use of force policies, what level of force would the Taser 7, would the Taser be within?
It is considered
Can you make this more
intermediate
entertaining,
weapon.
Nick?
So that's where it falls in our use of force.
Well,
Isn't there a way for these questions to be asked that are more
Pepper
entertaining?
spray, where is that located?
That is a lower level of force, the
I mean-
OC, that is used.
I mean, I didn't like the prosecutor's cross,
for
but at
verbal
least it
noncompliance,
kept my attention,
active
right?
yeah.
passive resistance, lower levels
don't
of
want to
resistance
fall
that
asleep.
officers would.
I mean, I'm over here building Legos.
Does
just to-
GRPD, do they consider the
pass the
Taser
time.
a less lethal form of force?
Yes, we do.
Now, is that consideration in the hands of a trained police officer?
That is correct.
In the hands of an untrained officer, would GRPD
Prosecco would make
classify
it more
as a less
entertaining.
lethal form
That
of
is
force?
true.
An untrained police officer, they wouldn't be allowed to carry it.
Well, let's just go into that because I think Detective Tubergen touched on this a little bit in his testimony, but an unlicensed person, as far as what are you required to have in order for any old citizen to carry a Taser?
In the state of Michigan, if you were to obtain a Taser, you need the licensing, like a concealed permit, as well as the training and certification form for that device.
I don't. I've seen video of it.
And is that whether the battery's in it, no probes, no anything within the device? Are you still required to have that licensing to even touch the device by law?
Yeah.
And what's the classification of an offense if the person does not have that licensing?
That would be a felony in the state of Michigan.
Is it felony to own a taser? I was going to order one. Glad I didn't. They're
I'm going to ask you,
$1,500.
I'd like to get into some of the Taser training, but just backing up a little bit, okay, because I can't recall how much this was discussed, but just to give the jury a little bit of context as far as training goes. When an officer is hired into Grand Rapids Police Department, what's their initial endeavor, or what do they first get involved with?
Right. We either send people to the academy to get their state certification, or they put themselves through the state certification. So then they are considered a certifiable police officer.
I don't mean to cut you off there, but what's their state certification?
Stupidest fucking thing I've ever heard.
State certification is a
fucking thing I've
15 to 17 week course, or sometimes in some colleges.
I'm getting a bit bored, so
It's,
I'm looking at your
the Michigan Commission of Law Enforcement.
Boring.
And what is MCOLS just in general? Does MCOLS also have standards that every police department is required to follow or abide by?
Yes, MCOLS sets the standards, the basic standards of what a police officer needs to be certified in.
This is all I'm hearing in my head.
Is GRPD certified or accredited, or do they follow MCOLS standards?
Yes.
Judge,
Michigan
quit
Commission
asking
on
questions.
Law enforcement standards.
It's not your
I
place,
ask you to
Judge.
say the whole thing every time. No more MCOLS.
I apologize.
I'm just joking. Let's stick with MCOLS. Now,
Oh, here, we might be able to wake up the chat with this.
once cut you off, after the person goes to an MCOLS certified academy, then what?
When we hire that individual, we put them through either a 6-week or an 8-week orientation. Sometimes we shorten it if it's a small class. If it's a bigger class, it's typically an 8-week class. Inside there, we now train them how the Grand Rapids Police Department does our policies, procedures, manual of conduct, and our use of force. We certify them in the taser. Obviously, we certify them with our firearms. We certify them with every tool that they have in their belt. Certify them with their pepper spray. We go over how to do traffic stops. We go over how to do contact and cover. We go over, how to police a burglary report, how to police a CSC, how to police domestic
basically
violence.
how to be a cop. Got it.
And then
how to be a
after
cop.
that 8
Move
weeks,
Yay!
we swear them in as an officer for the Grand Rapids Police Department. After the swearing in ceremony, they go into our field training program. It's a 16-week program at minimum that they go into, and it's divided up into 4 steps. Each step, the trainee is always partnered with a field training officer. And on each step, their level of work that they're supposed to do gets bigger. It starts off at like 25%, then it's 55%, then it's almost 100%. And then like the last 4 weeks is they're like shadowed by their FTO to see if they can do the job appropriately. And during that time, that's documented, their mistakes, their successes, and what training was needed to improve skill sets here and there to make sure that they are good and on a solid basis.
All right, let's get through this guy before lunch, so then we can call the defendant after lunch.
Yeah, and then wrap it up.
Friday
Now,
morning.
just going back to taser training, where is the officer initially trained on taser usage?
During our
Worst case scenario, we have 34 more witnesses.
And then how about after they're done with
the defense?
There's continued.
We have
all like
annual
this.
recertification of the
my
taser
God.
device every year built into our training programs.
And is that just only the department that requires that, or does the manufacturer? I can't recall.
I believe it's the manufacturer's policy to recertify every device or every officer with that device.
Now, when you instruct the officer going all the way back to the 8
At
week,
least the YSL was entertaining in all its absurdity.
does the manufacturer provide the department with materials that the department then uses to train the officer?
Yes, we are mandated by
I'm gonna use this one
the
for
manufacturer to use the
expert in
most
block.
I've never heard
up-to-date
someone say
version
so
of
many
PowerPoint
wrong
that they
things,
provide to
one
us,
after the other,
to go over
consecutively
the slides
in a row.
and educate the individual on how the device
forgot how
works,
to stream.
basic understanding of electricity. I believe you heard from Brian Childs from Axon explain some of that stuff. We go over all that in detail, and then we go through the practical exercises, practice just pulling it out of the holster, arming it, aiming it,
Yeah,
how
the
it works,
officers
the-
in his class.
the laser, the light, the nomenclature of the device. And then we put them through real life scenarios. Well, simulated real life scenarios, with role players. Role players wear protective suits and they have certain training cartridges that we can use that are safe to do so.
He's back on
you're
after
not
the morning
getting,
break too.
tased during them.
Oh, God.
It would just be for the target location on an individual in certain environments. When to use a taser, when not to use a taser, those things.
Now, are the officers then tested to assure their understanding of the taser?
I
Yes,
would be.
There is a written test as a part of their initial certification.
Now, are they? We heard from Mr. Childs already, but just to confirm, are the on the topic of warnings that's given by the manufacturer, are those warnings forwarded on to the actual officer who's going to use the device?
Yeah, they are presented
I'm
with
gonna
the same
spin a
warnings
ball.
that are in the PowerPoint.
I don't
They're
have
going-
protection,
gone
but I
over
have
in that
beer.
training.
And just in general, what are officers
Come on,
taught?
here. That's going to be
about the
it's going to be a
taser
longer
device
day
and-
if I start
and
drinking
its
now.
capabilities.
They are taught, and it's
Sadly, I have to
clearly
work
stated in
tomorrow.
PowerPoint that the taser device is a serious weapon and should be treated as such at all times.
At all times?
At all times.
What about
And,
the hands of the enemy?
Are there any warnings as far as the capability of the device to cause injury or death?
Yes.
You know what? I
there
think
are,
Officer Schurr is guilty because he
few
didn't
throughout the
properly
PowerPoint that
train
claim that
Lyoya
this
before he
device
allowed
can
him to take
cause
the taser.
serious injury or death.
Try not to go over everything that Mr. Childs already explained, but just in general, this Taser 7 device, how many cartridges could that hold?
It was equipped with 2 cartridges.
Can you give us just one more snapshot of deploying a cartridge and what that does?
Yeah, the device is equipped with 2 cartridges at that time. And there is a close quarters cartridge and a standoff cartridge.
More the aftermath
We
of the stream than
went with
during the stream
one of each.
that I'm
So the
that
close
I'm really
quarter
concerned
cartridge
about.
is in bay 1 and the standoff cartridge is in bay 2. Bay 1 means if you pull the trigger, that's the first probes that are going to go out. Close quarters has a 12-degree spread. So if I use my fingers, the top one is straight, like Mr. Childs says. The bottom one's at a 12-degree angle down. It's
That's
designed
interesting.
for that close
You
range.
use the 2
deployment.
fingers.
Get that optimal 12-inch spread for potential incapacitation at that time. The second cartridge is called a standoff cartridge that has a 3.5-degree spread. So obviously
Gentlemen,
the spread
if
is
you
minimized.
use this,
So you can do it from a further distance of that individual and still try to obtain that 12-inch spread if the probes hit that individual.
If I could just approach the witness, Your Honor, with People's Exhibit number 23.
Yeah, Brandon, it is 5:20 p.m. where I am, but I have work tomorrow.
We've already admitted that. Does that appear to be a Taser 7
Yes, it does.
without the battery in it or any probes?
There is no battery. There are 2 cartridges in here, but no probes in it.
Okay. So that
he
actually
better
has the
explain the
cartridges
condition
on
of the device
Yeah,
than
if
the
you push
expert.
this top button, they come out,
right.
and you can see the difference. One's
Zoom
clearly
out,
states
man.
12
Zoom
on it. The other
out.
one's 3.5. They also have it designed by color,
Jesus Christ.
so you know which one you're putting in the proper location.
It's not even in focus.
Now, does Axon
Zoom out.
warn, and then you in turn warn the officers that you should avoid using the taser on certain parts of the body?
Yes.
And are the trainees taught that if you administer the device on sensitive areas of the body, that in and of itself could cause serious injury or perhaps even death?
Correct.
Batteries and probes.
Can you just list I'm not going to ask you in depth since Mr. Childs went through quite a bit, but just in general, what are those areas that officers are trained to avoid?
Yeah, obviously, and you saw in the pictures of the green little dummy, whatever, the
Avoid
yellow
having
area
the suspect take your
of the head, the neck, and the chest, the heart to dart thing. So the preferred areas are the green. So the extremities, the large muscle groups of your legs, your entire back. But we want you to avoid the head because of the eyes. We're sending a probe that has a straightened out fish hook. We're avoiding the neck area of the individuals, as well as trying to avoid directly over top of the heart, as well as the genitals. I don't want to forget that.
All right.
I can't forget
And
the
even
genitals.
after both cartridges are deployed, okay, and the probes are out there, the 5 seconds
This man,
passes.
out of
Does
sight,
that
out of
device
mind.
have the
That's why
ability to
this man forgot about
re-energize
the
the
genitals.
probes and even the wires?
Yeah, if both probes are deployed into the field, the arena, or whatever you want to call it, that you could re-pull the trigger and activate all 4 probes as well as the wires, or you could hit the arc switch on either side, it's ambidextrous, which has been pointed out.
Sir, I was going to go through the voluntary. Our officers provided the opportunity to have a voluntary tasing, or recruits actually, back during the 8 week.
Yes, they are.
And we already had a witness testify and go through some of the video on that. So I don't want to necessarily go through it all over again, but
right now live in the
is
courtroom
that
for a
required
demonstration.
that the trainee take that on?
It is not required. It's encouraged. We want them to understand the capabilities of this device and feel what neuromuscular incapacitation is. We also want them experience that when you are experiencing NMI, if I can use the shorter version,
please,
that you can still hear commands from the person that is tasing you. So they know when the ride is over that they understand what the officer wants them to do at that time.
It's just the questioning is so boring.
The setting for this voluntary is a fairly controlled setting.
It's a very controlled setting. It's a very sterile environment. Everyone is required to wear eye protection. We
I feel like the
offset
best
everybody,
way to train an officer
behind
is
where
in a
the
very
probes are
sterile
going
setting.
down range, so there
They're
isn't
going
an
to
errant
encounter,
probe that accidentally
suspects
strikes
out
somebody. We have spotters there, so a lot of the risks of a taser is the uncontrolled fall that could create a lot of injury as well. And so there's spotters, or we'll start them on their knees or even laying down to avoid that fall risk. He can still accomplish the same goal and experience NMI during that time from a laying down position.
Thinking about lunch, Nick. What should I
as
eat?
well as standing.
We went through the video yesterday. And have you had the opportunity to review the voluntary tasing of Christopher Schurr here back in his academy?
I don't want to probe into
I
that.
can pull it back up, but
or
approximately how
interject.
far was the device from Officer Schurr when the probes
Oh,
were
good
deployed?
night.
In the video that was displayed, Officer Schurr was laying down.
Thank you.
The officer, the instructor that was that tased Officer Schurr, it's probably 1 foot or 2 foot. It's not super clear. Just I think the spotter's in the way, but you can tell the proximity was very close, and I believe it was to the lower portion, to his legs.
Even at that closer distance, does it appear as though Officer Schurr still felt the effects of the device?
Yeah, you definitely can tell by his reaction.
I don't want to wait in that line.
The immense pain that he's experiencing, and in my opinion, it was a lower extremity, lower hemisphere. You heard that term from Mr. Childs, exposure. So you can see him kind of crawling still because it didn't get that full above and below lockup, but he definitely couldn't use that leg, or if it was in both legs at that time.
It appears though he did not have the ability to really control his whole body during that experience.
Correct.
And what model was that back in?
Well, they're talking about the training.
2015, we were using the X2. It was the 2 generations below the Taser 7.
Did the X2 have something different than this Taser 7, particularly?
You know, these guys all get like drunk.
With its
on the
ability in
weekend to
those
play with
close
these,
range situations.
Yeah, the X2 was equipped with different cartridges. They were designed at a 7-degree spread, and that's was designed again trying to get that optimal 12 inches, and that's why they changed, or they continue evolving their product. But at that time, the X2 had a 7-inch spread, not the 12-degree like the close quarters or the 3.5.
That's what she said.
So if we had the
7-inch spread instead of the 12-inch spread.
Similar distance with the Taser 7 device, with the first cartridge that's deployed, what might be expected as far as where it may?
If you did the voluntary exposure with the Taser 7 with the close quarters at that distance, they would get a bigger spread, more likelihood of experiencing full NMI lockup at that time.
So going back to the academy, was Officer Schurr trained going all the way back to the academy, I call it the academy, the 8-week, that it's acceptable to use the device within closer distance? Would that be fair to say?
That is fair to say, yes.
And it appears that even at a closer distance, even with the older device, it still had a pretty significant effect on Officer Schurr. Is that fair to say?
That's very fair to say.
Now, when the probes connected with Officer Schurr, I think Mr. Childs mentioned this, do you all sometimes refer to that as taking the ride?
Yes, we do.
And how long does the ride last?
It is designed to last 5
Ladies,
seconds.
can you relate?
What happens if the person continues to hold or they repeat the ride after 5 seconds?
It depends on the configuration of the device, the software, the computer of the device. If in older models, if you just held the trigger down, it would keep going for as long as you went until you actually let go of the trigger. In the Taser 7, they have that automatic shut off. All
right, we're going to speed this up a little bit. You good with that,
after
Nick?
5 seconds. But it can be re-energized at any time. Any other trigger pull would send a second cartridge, or if you hit the arc switch, you re-energize the one set of probes that are downrange.
Does Axon warn against repeated or continuous deployments or
Yes.
ignitions? And I apologize if I'm using the wrong terminology on this, but now our officers therefore trained not to have continuous or necessarily repeated applications, to have some limit on that.
Yes, officers are trained. If you're not getting the desired behavior change, try a different tactic. You don't want to keep using one thing over. It's more dangerous with the taser because you're putting that much energy into an individual and I'm not a medical person, but from my training, is repeated exposure to extreme amount of pain. The body's either adrenaline's going to go really, really high or dump, and that can be dangerous at that time.
Sorry, I'm just trying not to ask you some of the same topics, but just moving on. And I believe this was covered with Mr. Childs, but both cartridges already deployed. And then subsequently, an individual has contact, even just contact with the probes or perhaps even the wires. The trigger is pulled. Why don't you explain? Can those probes and wires be re-energized?
Yeah, the probes and wires can be energized once they're outside of the device and either in a person on the ground or wherever they're at. So anytime you reactivate this device by, again, pulling the trigger or pushing the button intentionally or unintentionally, it's going to cycle again for another 5 seconds. So the energy is out there.
Now, even if both cartridges are deployed, I know we've talked about this, but does the device still have a drive stun capability?
Yes, it does.
And are GRPD officers trained on how to administer that?
Yes, they are.
And are the materials from Axons, as far as warnings about drive stun, are those forwarded on to the trainee? Or the
Yes,
officer?
they are discussed.
And is it warned to officers that drive stun alone to sensitive areas can cause serious injury or death?
Yes, it's in the material, and we go over it.
Now, sir, were you able to listen to the testimony of the prosecution's expert, the law professor?
Yes, I was.
Mr. Stoughton? And he characterized, did you hear him characterize a drive stun to a thumb?
I did hear that.
Do you have kids?
I do.
You let their kids play with their thumbs in their hands. Is that fair to say?
Yes.
Would you let your kids, untrained in particular, play with a drive stun?
First off, it'd be illegal for me to do that. But no, I would not. Absolutely not.
You mentioned continuous pain and how the person may dump. Now, what if somebody, as far as the drive stun function, somebody who's depleted, exhausted, a continuous drive stun, could that have some type of effect on them in this dump?
Yes, it could be. If a person is exhausted, that a level of pain would be dangerous.
Yeah,
Have you been drive stun before?
I had.
Professor,
And is there anything that you could characterize the pain to, or other folks that have had
it's
before?
commonly perceived.
So is or was this judge, by the way? She actually taught some classes at my former law school, which is concerning. I looked that up. And I'm really concerned, especially with some of the rulings that she's made.
A blowtorch is extreme amount of pain. It's localized pain, but it is unbelievably painful. So if you were to press a blowtorch against your skin, you'd want to get away from it as fast as you could.
a Grand Rapids Police Department officer, and we'll stick with the drive stun function. When is a Grand Rapids police officer trained to use the drive stun? How?
The drive stun capabilities primarily used for a third point of contact to close the circuit of, if you deploy 2 probes and one misses, you can touch them with the device activated in another spot on their body to close the loop, close the circuit. So the energy goes through the top probe, through the person, and then to the end of the device. And then that could create the neuromuscular incapacitation.
I'm gonna stop here and take a break for about 15 minutes. So,
She's not.
So we'll come back at 10:35.
She's inappropriate in all the wrong ways. Like, I agree with some of her rulings, but I don't agree with her asking factual questions of the witnesses in front of the jury. That's not her role. She does a lot of inappropriate things, I think, in front of the jury.
Yeah, it is. She makes a few good points here and there, but I feel it's like well, the judge,
to say that the videos are not relevant, even though they're the exact same videos that the state played a dozen times. That sort of stuff is like, really?
Yeah, I mean, the prosecution played the videos and their mash up of the different videos. Why wouldn't the defense be allowed to do the same?
Or to say that the expert's opinion, or that the defense couldn't question the expert about statements the defendant made because it's hearsay, flies in the face of the court rules, which says that hearsay statements are allowed to the extent that they inform an expert's opinion, which is what he testified to. He used the defendant's statements to form his opinion. Okay, cool. What were the statements? And although I partially blame the defense for that.
Yeah. I mean, you have to make the correct arguments under the correct law to get through that loophole, and they didn't.
What are we going to watch here? Are we going to see some video or some slideshows? What are we watching coming up? Oh, the warning label again. Everyone's got to look at the warning label. We're 24 minutes behind.
Could you please pull up Exhibit K?
The
J, please. I believe.
Soy boy, you mean the officer, the defendant? He did not testify,
Sure,
but he
I think
made
where we left off, you were talking about.
He made statements in his reports, and that's what was used. And so that they're not offering it for the truth of the matter asserted, which is hearsay. They're offering it as a basis for the opinion that the expert formed, and that is appropriate to admit. And I think it was a bad question by the defense, and then the defense didn't know how to move on and ask a good question. Plus the judge's ruling, it was just all kinds of bad. Everybody's stuck in that scenario.
Officer on using this drive stun function, and just to synopsize, and correct me if I'm wrong, and that GRPD trains to use the drive stun along with the probes to create greater spread. So a third point of contact, you sometimes refer to it. Is that right?
That is correct.
And let's just say you say third, but if there's even one probe even on an individual, and then the drive
that's
stun,
essentially
that's
what the judge said,
right?
That
or
is
agreed
correct.
with the prosecution about.
It's designed because sometimes a probe, depending on the clothing, or it still could be in contact with that individual. Maybe it's in their wallet or in the belt or in a large puffy coat, so it's not close enough to the skin. But one probe is actually in the skin, so that's the differentiation of a third point of contact to close the circuit.
Now, if we could just play this video here, Mr. McCollum.
Oh, yeah. Yeah, Soy Boy, the same guy that testified in Potter testified. Yeah, Professor S, whatever his name is. Yeah, that guy testified 2 days ago on Tuesday. So day 2.
Does that appear to be a training video? I know you've sat through some of the trial. It's Officer
Yes,
Schurr.
that is a training video designed scenario to do a third point of contact.
And the music and all, it's part of like a training montage for the officers. And
at the end of the orientation,
he was a district court judge,
videos like you've seen in there and provided to the
he's
the
different
officer and
judge. It was a
family
district
for
court
their swearing in program. It's a big day to get sworn in and become a grown-up police officer anyway. So it's a montage of videos just to kind of remember the training they went through.
I heard you pick the music for those.
I do not.
Now, if we can just play it again, I just want to, when Officer Schurr initially goes to pull the device out of his holster, he's back. All right. If we could just watch this moment here, please. All right, that's good. So you explained that the taser's on the opposite side of his dominant hand. Is that right?
That is correct.
And did you see him attempting to get the device out of the holster?
I did.
And is there some type of action it takes to get the device out?
Yeah, the holster that's designed for the taser is a retention holster. It's to keep it secured on our person, so we don't get it taken away from us. But it takes some practice because there's retention methods on it. This one, I believe, has a two-step. It has a thumb snap as well as a hood. So you got to break the snap and then roll the hood and pull the device out. And even pulling the device out, if you're pulling the device out at a weird angle, it can get hung up inside the holster. It's very similar training because this looks like a gun. It's very similar to our guns. Our guns have retention holsters. And if you break all the retention methods, but still pull it out on a weird angle, you can get stuck. And you can see officers kind of doing that jerky motion.
And is the model in that 2015, was that the Taser X2 model?
Yes.
And the device, the Taser 7, did that have a holster of its own?
Yes, it has.
Because I'm sure is waiting for us to break out the second and beer.
To fit the tight around the weapon. Holster.
Save all the super chats and gifted memberships until tomorrow on my birthday stream. I will bring up...
Feel free to super chat me if you guys want.
No, save it all for tomorrow.
I would estimate about 6 inches, maybe 8 inches, right around there.
Oh, you're asking for 6 to 8 inches.
That's an appropriate distance to use that device.
That's what she said.
Because we're talking somehow, this trial's turned a lot into different policies. Okay, there's a lot of different policies and theories around the country. Is that fair to say?
Correct.
And the acronyms go on forever, right? As far as all these different bodies throughout the country on police practices.
Yes.
And Police Magazine and all sorts of other literature out there on police practices.
That is correct.
Now, this officer right here.
Yeah, save them off for Friday.
Is he trained on every different
and then still
policy
give them to MLS?
Every magazine around.
No, he is trained to
So it's some magazine or some.
Oh,
some other
Erin was nice to you.
South Carolina says, you shouldn't do this. Is he expected to know?
Thank you, Aaron, for the $20 super chat. It's nice to be back for a trial stream. I miss these.
He's expected to perform.
If I can figure out a way to be like 20% more efficient at work
our policies
while I'm
common
out
practices.
streaming trial, this could work.
Not every common practice is written in all these policies. Is that fair to say?
Correct.
So even if there's not policy on certain, whether you can or cannot do this, there's just a lot of generally accepted practices within your department.
Yeah.
And can some of those generally accepted practices on the mind of Officer Schurr differ from all these other bodies out there?
Correct.
Did you see they are coming out with a new Snow White film?
Now,
a new one?
Yeah, but this is because the
taser
protection has expired.
Axon warns, I think you've already acknowledged the taser is a serious weapon, should be treated as such at all times.
At all times, yes.
And can that be even after both cartridges are deployed?
It's a horror
As I
adaptation.
believe, as Mr. Childs discussed as well, does the device have
like the Winnie the
ability
Pooh
to be
one.
energized?
Yeah.
Yes. Does
The
it still have
princess
drive
must
control?
overcome the horrors of the dark
person still
forest and make
experience
unlikely
NMI.
friends with 7 murderous dwarfs.
That sounds even better than the remake. I haven't seen the remake, but I'm going to go see that
There's
one.
been some
I'm
discussion.
going to see this
Is
one.
weapon retention a common topic?
Yes.
But Officer Schurr is also trained. Is it true that Officer Schurr is also trained that he can use a device like the taser within arm's length of an individual?
Yes. And to clarify that video, the reason we're looking and designed that video that way, or that training scenario, is if you are up close to that individual that you have to use the taser on, we know it's going to be a close probe deployment, so it's not going to get that NMI. So then he moves to a different part of the body to get a bigger circuit, because it's smart enough to know that these two probes happen to be 1 inch or 2 inches apart. but then there's
Yeah,
another
the probes needs to be an
spot
inch
on the
apart.
body. It creates a bigger circuit, getting the large muscle groups and potentially creating enema.
And is that something that officers are able to achieve out in the field?
Yes.
As far as close probe,
Basically, I've
follow
been
up with the drive
streaming
stem, that's something
things
that officers do
that
out
I
in the
wanted to
field.
talk about.
Are you aware of
and had
whether
time to
prior to
talk
April
about.
4 of 2022, whether this officer was successful in a
I'm still
similar
not
close
sure
probe
what I'm
with
doing.
follow-up?
But I'm
not
happy
aware
to be here
of
with
that, but I
Nick
know what
streaming this trial and all of you.
The different witness, perhaps. So thank you. Now I want to get to the topic of April 4 and the encounter here. Now, have you had the opportunity to review the videos from this case?
Yes, I have.
How many times approximately?
Let's
A few
play the
dozen.
videos. Let's play the videos again.
Do you feel comfortable, familiar enough with the content of those videos to answer some questions? And I don't even think I necessarily need to pull up the video at this point. Do you feel confident enough, have enough knowledge?
Probably actually a good idea. Don't play the videos for the defense shouldn't be playing the video. It just looks bad.
When you go back to do an evaluation of an officer, their decision to use force or handle a certain situation, what is how do you gauge that? How do you judge assessing an officer's actions?
Obviously, we need to review all the videos that are attached to that incident. We got to review the police reports, the use of force reports, going along with that information. And we have to view it in real time, at that time, not information. I know you've heard this before, not hindsight. As I sit in my office on a Monday morning looking at what happened over the weekend, I have to put myself in that lens of what's going on at that moment. What information do I know that they know at that time? The totality of the circumstances of what's going on, the individuals. I believe you were presented earlier.
I will say there's been a lot of things that I've said, and
totality
then
of
immediately
circumstances,
after
what
I've said it, they've done it.
could
or
have
said it.
benefit or could have an explanation of why they went this way and why they went that way. Anywhere from the size difference of the officer to the person, the weather, the type of resistance, all of those things all combined. And then we do a review of, was it within policy? Was it within following training at that time?
Does the officer always have to use the best tactic or make the best decision in that moment to still be deemed reasonable?
No.
Does it depend on the circumstances? Is that what you're explaining?
Yeah, it is a very dynamic, evolving event. So there's a lot of things that go into that factor. We have to weigh that stuff in judging the reasonableness of that action.
Since we've been focused for the most
we get
part
a song for
on
taser?
taser, I just
Yeah.
want to ask you about the taser usage in this incident on April 4th with Officer Schurr. Was it reasonable for Officer Schurr to move on to a taser device in the situation he was in?
Yes, when Officer Schurr decided to pull his taser out to attempt to use it in this situation, it was reasonable. He's already tried lower levels of force that were unsuccessful. And we're training him, again, if it doesn't work, move on to the next, try something else. Ultimately, we're trying to change behavior, get compliance. And at that time, he introduced the taser in that situation.
Anything else about Officer Schurr? At the time he pulled out his taser, just looking back and watching this, the length of the fight mean anything?
Yeah, it's a very big deal. I mean, we go from driving around the city in a very calm but alert manner to 0 to 100, in seconds. So in my review of the videos, you could already tell, he was become to a higher level of alertness when the driver popped out of the car and he's not complying and he's trying to figure things out. And then obviously he got assaulted. They run around the car and he's trying lower levels of force. He tried to tackle him. He's trying to control him and he's not gaining anything. It's not working. So then he introduced the taser at that time and attempts to use another level of force, use another tool on his belt to gain compliance, change behavior, and get compliance to control the situation.
In the taser, was that a reasonable device for him to turn to in that situation?
Yes.
Okay. Now,
I do like this
as
line
far
of
as
questioning. It's just
watching
a
the
little
video,
tedious. This
he's
is
in close
set up
quarters
too,
with
by the
Mr.
way,
Lyoya.
guys.
Is that right?
That is correct.
It would
And
be good if this
it
was
appears
real
as though
time.
He attempted a close quarter deployment. Is that right?
That is correct. It appears they're still in contact. Officer Schurr has a hand out trying to still gain control of Mr. Lyoya at that time as he's using the cross draw to taser and attempt to use that.
Right now, I
So
still
within
say
arm's length.
yes. I feel like he needs to testify.
As we all know, the driver grabbed onto the device. Is that
Although
fair
I'm
to
getting
say?
more and more comfortable
Yeah,
with the
clearly,
idea
yeah.
that he doesn't.
Now, after that point, as far as somebody
Not
attempting
all the
to,
way there
to
yet.
take a weapon from an officer, is that a pretty serious situation in training?
That's a very dangerous situation. Why are we taking this weapon away from me? Why? What is going on at that time? It's easy. If you and I are fighting and you take my wallet, you're taking my wallet to spend my money or use my credit card. So that's an assumption, but it's not just to take it away from me, you know? So, I mean, as an officer, you're taking away a tool, a very serious and dangerous tool off my belt. It's a very scary situation.
So when the matter gets to a point where, does it appear at some point that the driver is able to have exclusive control of the device?
Yes.
And going back to your analysis there, in the eyes of an officer, after a couple of minute fight, would it be reasonable for an officer to fear that the individual may use the device on them?
Yes, that is reasonable.
And based on your review of the video, no hindsight, was Officer Schurr reasonable to resort to deadly force in this situation?
Yes, I believe, in my opinion, he was in fear that this device was going to be used against him. He would be incapacitated. He's already exhausted at that moment.
I guess I'm going to check. He can't testify to what Officer Schurr believed. That's what we've gone over numerous times in this trial, and that's inappropriate for an expert to opine on.
Yeah, I can back it up. A reasonable officer.
Okay, so I'll strike the answers with respect to the defendant because this witness can't possibly know what was in his head at the time. So I'll strike.
See, that's why he still needs to testify. Especially with these instructions. The only way we're going to know what was inside Officer Schurr's head
if I could
is
just
if he
rephrase that,
testifies.
based on your knowledge, experience, the proper rules to judge, no hindsight, would it be reasonable for an officer when an individual has disarmed them like that to fear that the individual may use the weapon on them?
Yes.
And is there anything noteworthy in that video that takes place just prior to Officer Schurr drawing his weapon?
At that time, the suspect in this incident had complete control of the taser and had switched it from his left hand to his right hand.
And how about the positioning of these two persons just prior to the firearm coming out?
It appeared in my review that Mr. Lyoya was getting back up and turning towards Officer Schurr at that moment.
Okay. Would an officer, with the training that Officer Schurr had, would it be reasonable for that officer to be in fear that the individual may use the device on them under the totality of the circumstances?
Yes, based on the totality of circumstances, everything that's portrayed so far at that moment, there would be a reasonable fear of another officer at that time.
Now we're finally getting to the good part of this
And
testimony.
if an officer reasonably fears serious injury or death, are they required to wait for the individual to actually aim the device at them?
No.
Because what happens when somebody aims a device at you?
Action's faster than reaction, so we don't have to wait for someone to hurt us to do something.
If there's reasonable fear, serious injury or death, what level of force is the officer authorized to move on to?
Deadly force.
Okay. Just one moment, please. That's all. Thank you, Your Honor.
So I go over one of the things you talked about earlier with Mr. Dodge. These questions on the defendant doesn't have to go by South Carolina policy, Florida policy. You are certified under CLIA, right?
Yes.
Once again, what is CLIA?
It is the gold standard of policing. It's to set the police standards across the nation of policies and procedures in place.
And the gold standard means that you actually have other departments from across the country come in and look at your policies.
Correct. It's quite a lengthy process. They review through all of our materials and we obtained our accreditation.
Bricks at
and
this.
I think it was 2019. Only like 5% of the agencies in the country were accredited, and we were one of them.
So if your policies are outside generally accepted police practices, you won't be certified by CLIA, will you?
Correct.
So you just did. Oh, you just did.
I don't know the exact acronym of CLIA.
You don't know exactly what CLEA?
I wouldn't want to guess right now. I understand what it is.
I'm sorry, I'm trying to listen, but I thought Commission on Law Enforcement Standards. But whatever. The point is, CLIA is a gold standard. Every police has policies that are generally accepted by the police practices because you got CLIA certification.
Correct.
Why are they talking about gold standard? This is one of the gold standards is only for sciences or
our policies have
best
been
practices
that accreditation.
a gold standard. I mean, gold standard is how do you put evidence in an evidence bag and get it to testing? Then you have a gold standard.
Yeah. I don't know if this really helps or hurts. I'm going to listen to this at real time.
Yeah.
Our policies have been reviewed and to give us that accreditation, but we hold up Officer Schurr to our standards.
Just going into it, the taser we've talked about, the taser is considered an intermediate weapon under Grammar Police policy, right?
Correct.
And it's a less than lethal use of force.
Yes.
And even, talked a little bit, you can switch off over to my PowerPoint or my computer, please.
Hopefully my new camera cable will come in before our afternoon.
You've had an opportunity, were you in here for the child's presentation?
Yes, I was.
And you recognize this slide?
I do.
This is the slide for the Taser 7 presentation that you give as an instructor.
Yeah, I would have to see the version number, but yes, it is.
Okay. But this is one of the slides that's on there. You recognize that?
I do.
Now, studies show that CWs are effects comparable to less than fighting or fleeing, and that's you tell these officers that.
The exertion of the device is like you're fighting or fleeing. Yes, that's what it causes after you experience NMI.
Now going to that, we've talked a lot about
Experience NMI. Okay.
you're not risk-free though, right?
Correct.
Now, one of the things you do talk about, sorry.
Yes, slide pie over at my rumble. Yeah, the cameraman is actively trying to be artistic.
The cameraman is insane. I don't know what he's doing.
There we go. This is one of the slides still. This is kind of the main warning slide, if you will, right?
Yes.
Now, they just don't give you the slides and tell you to talk about them. They give you kind of a script, a thing to tell the officers, right?
Yeah, there's notes attached.
One of the notes, and particularly with this side, on this slide, is the National Institute of Justice, and the 5-year study found that taser energy weapon deployment has a margin of safety or error greater than most alternatives. That's one of the things you tell them, right?
We just, not that specific.
What do you mean, you don't follow, so they give you the stuff and you don't follow?
We read the slide and go through it, and we don't go into the minutia of who did the study on that.
But you say the basic part of it is that the significantly lower risk of injury than physical force.
Yes.
So you tell the part about agencies who use taser decrease suspect injuries requiring medical attention by 45%, and officer injury requiring medical attention by 80%. You say that?
Yeah, we go over the reasons. The taser was designed to reduce a lot of things. Baton strikes for one. They're ugly. They're nasty. It looks horrible to hit someone with a metal rod. This reduces the injuries because it's designed to not go hands-on if you don't have to, if it's safe to do so. And then it's designed to reduce the injuries to the officers as well as the suspect.
Okay. And part of it's not go hands-on, so you have that distance. Part of it is distance, is having the ability to use distance between you and the subject you're trying to apprehend, correct?
Yeah.
Where's you going with this? It sounds fairly pro-defense right now.
Go to Exhibit 32 now, Your Honor. I'm trying to make that. Once again, we've got over use of force policy. This is 9.9-1.3. This is the use of force that's kind of in place for Grand Police use of force.
That shows for everybody. You just got to come over here and grab it.
Recognize this subject, potential subject actions or level of resistance.
Correct.
You testified before. You testified back in April, or back in 2022, whenever the first prelim that you talked about.
Yes, sir.
You testified that Patrick was demonstrating active aggression, correct?
I believe so. I would need my transcript to confirm that.
Would that help you? You want to refresh your recollection? You want to take a look at that?
Yeah, please.
Referring to the preliminary exam transcript, page 33.
I feel like the prosecutor's doing a better cross than the defense did direct with this guy.
Yeah.
Just starting on line
We'll see where he's going with this.
kind of going over into page 34.
Yeah. I mean, it was contextually, I don't think we were talking about this case. We were just talking about use of force.
So active aggression, that's what Patrick was doing. Active aggression in this situation. Your answer, correct.
Yep,
Oh,
those were
sorry.
some bad
I see the
videos
bottom
and
line.
the
But
Detroit
yes,
one.
correct.
Okay. So Patrick was engaged in active aggression. There's a distinction there between active aggression and deadly force assault, correct?
There is.
Just because somebody's in active aggression doesn't mean an officer can use deadly force, right?
In that context, correct.
We mean in that context. What do you mean by that?
It's not a black and white answer in questions. And so, I mean, strictly the way you worded it, yes.
Well, you can't use deadly force for somebody challenging an officer, right?
Right.
You can't use deadly force for somebody punching an officer.
Correct.
You can't use that deadly force for somebody kicking an officer.
Again, contextually, how many times have they kicked me? How many times have they punched me? Am I about to lose consciousness?
All right. All right, and that's fair. I mean, but it's a continuum. So
Right.
it's under, if the 10-year-olds reporting kicking you, you're not going to be able to use deadly force, right?
No, sir.
But if it's middle linebacker with the Detroit Lions and they're pummeling you if you're about to pass out, that's a whole different thing.
Correct.
So the whole idea is the reasonableness, like we talked about on the continuum.
Yes, sir.
So how reasonable was it given all the facts and circumstances?
Yes.
Now, once again, going to this taser thing we talked about, all of a sudden we're getting this, the taser's taken away. That's deadly force. That justifies deadly force. Where is the policy for that?
Yeah.
Where is that?
Again, you're looking for the black and white answer. It's the gray area. It's the totality of the circumstances at that time.
Where is the policy that says if a suspect takes a hypodermic needle with an unknown substance and holds it to the officer's neck, that's dangerous? Why haven't you conceived of that specific scenario? That's what they're asking. They're asking these weird hypotheticals that, you can't account for every possible situation. But an officer losing his weapon and the suspect gaining control of it, to me, is common sense. It's inherently dangerous. I don't know what else to say.
So part of the reason we do voluntary exposures is to know how this device affects you. And so the level of pain, the level of exhaustion. Add that to the totality of circumstances of extreme exhaustion after a 2.5-minute fight. And it's not written down. It's the totality, and that's what we're going
And
on.
that's what I'm going for. So it's not, there is no, hey, taser's gone, you get to shoot him, right?
Right.
It's based on, you got to take a look at all the context, looking at the whole situation, right?
Correct.
And then you make that judgment call, not based on hindsight, but what would a reasonable officer know at that point in time?
At that time.
Now, one of the things I questioned him earlier, I mean, you were part of the training unit, correct?
Yes, sir.
And I think were you in charge of the training unit at the time this all happened?
No, I was a
You just
captain
left?
at that point. Yeah.
You just kind of left. It was
Correct.
transition. One of the things that was talked about, you do scenario training,
Yes, we do.
and some of that scenario training goes for a long time, right?
Yeah.
It's not for just a couple minutes. You go for longer than that, right? Depending on the facts and circumstances.
In the training environment?
Correct.
Yeah, we try to experience, in the police academy, when I went through, they had us go into a boxing ring and do a full round of boxing to see how tired and exhausted you are fighting another individual, to show that we are not trained professionals that can go 10 rounds.
Sure. But that's part of the training because you don't know what's going to happen out there on the street.
Correct.
Things don't happen in 10 seconds, 20 seconds. You may be struggling for a long time.
Yeah, there's potential for that.
There's
Yes, it's a
potential.
very risky job.
So I think the questions
You heard the
are
testimony back in there. You said sometimes someone
better
will have
listed
long,
from the
drawn
state
out
than
physical
the defense.
altercations on a wrestling mat.
Yeah, we do that during the orientation to show them, what their capabilities are at that time, and to show them, if someone is a more advanced fighter and wrestler or whatever, they could disarm you of all your stuff during
Tussler. Sir, it's
this
called
long,
tussling.
drawn out.
They're a better
in
tussler.
a safe, secure training environment.
And one of the things you talked about is going through this training is you have to have the ability to maybe transition, if you will, from different
Yes.
tactics. Right? So in this one, what we saw
I
in the
agree.
transition, we saw a knee kick,
Yeah, knee strike.
Knee strikes, we saw a few of them, right?
Correct.
We saw a taser.
Correct.
And we saw a gun.
We also saw a tackle. We saw.
Is a tackle a trained thing?
It's an untrained thing, but it happens. Very common in police practices.
I like this guy. He's just like, yeah.
We also saw, he attempted arm bar controls of trying to grab his wrists and pulling them back, trying to get him into an advantageous position early on, to get your arms behind your back, like we would handcuff somebody. And so, yeah, we had, soft, empty hand techniques of, grabbing the arms and the wrists and trying to pull them behind the back, the tackle, a strike, a few knee strikes, and then the taser.
Okay. That's all you saw in this incident?
Yeah.
And then for your arm.
I want to know, some jury questions would be good.
This topic of try different things. Chris, Officer Schurr here, tried several different means of what level would his force have been in that situation? As far as the knee strikes, and what are those referred to on the level of force?
Those are hard, empty hand techniques. A kick and a strike is where we would put that at that level.
And he tried several of those?
He did.
And at times, perhaps, let's say an individual is extremely intoxicated. Okay, can those be ineffective?
Yes.
And if you add exhaustion into the equation, would that affect the officer's ability to continue to try the same level of strikes?
Correct. Yeah, exhaustion would be less effective because now,
I'll get some
human performance, you don't have as much power 1 minute into a fight than you did the first minute of the fight. You're getting tired. Your muscles are losing their strength.
And just in general, to some of these strike tactics, can they be ineffective on certain people, such as intoxicated persons?
Yes.
And can that include even the asp or the baton?
It can include anything, yes.
Because what is the asp or the baton? Is that striking the individual?
That would be, yeah, striking the individual.
Asp strike, baton.
So if other strike mechanisms were ineffective on an individual, would the officer need to keep going through all of those same types of force to try everything possible?
No. Long ago, they used to have a 1+1. They do this, we can go to this one, do this. And then it's been decided through the courts. That's not necessary. You have to know what this level of force, in that officer's belief, would not be effective at that time.
Okay. And really, but you don't necessarily have immediate escalation. If you try this, go to this, go to that, you can always stay one ahead of the next, the step prior, right? Or the resistance or the aggression of the individual.
Yeah, the ultimate goal is to gain compliance and to try to get that done as quickly as possible so you don't have to be exhausted, but it wasn't working.
Okay. But if an officer's tried a level of force, strikes, lower physical controls, and they're not effective, is the officer trained that they can then move on up to a next level of force?
Yes.
And if that level of force is ineffective, can they continue to go up the spectrum there?
Yes.
They don't have to try every other possible means below to move on up.
Stop asking questions because I know where this redirect's going to go.
Talk some about these this disarming of a taser. If an individual disarms an officer of their weapon, can it be deadly force?
Yes.
Under the totality of the circumstances, correct?
Correct.
There was some mention of active aggression. Is you don't necessarily use deadly force against active aggression, correct? It doesn't have to be your first resort.
That is correct.
Can it escalate to deadly force pretty quickly?
Yes, it could.
So, for instance, here, if the driver started out with those functions, but once a weapon gets thrown into the mix, can that change the equation pretty quickly?
Yes, it could.
Just one moment.
Yes,
please,
they
John.
do to some extent, but if the county itself is being sued, then they usually have different attorneys.
That's all.
But the county prosecutor will handle a lot of.
Disarms you with a taser. So if I grab your taser, and I stand there, can you shoot me?
I don't have to wait for you to tase me.
Sure, I'm not saying that. But can you shoot me? I grab it, I stand here.
again, contextual. It has to be the totality of the circumstances. But could it be reasonable that I fear that you're going to use it against me? Yes.
Okay. If I turn, I'm away from you. Can you tase me?
Tase you?
Or shoot me? Excuse me.
Again, action's faster than reaction.
Yeah. So this is cross-examination. This is the prosecutor right now, Brandon. He ended the last witness with the same sort of scenario. If I'm just standing here with a taser, can you shoot me? And both of them answered correctly. It depends on the rest of the circumstances. We're in a courtroom. If you grab this exhibit and we're standing there, no, I wouldn't be in fear, right? These last two officers did well on cross. They actually did better on cross than they did on direct.
You have to base it on the whole entire situation. We can't just have a black and white answer here.
So the fact that you took the taser doesn't allow you to shoot him. It's not based on the totality of circumstances, right?
Say that one more time.
The fact that somebody takes a taser doesn't mean you can shoot him. It depends on all the facts and circumstances. You got to take a look at the whole incident.
Correct. You have to take a look at the whole incident.
And I guess going to that, since you're the taser expert, has a Grand Rapids police officer ever been disarmed with a taser and shot?
The Grand Rapids police officer? No, they've been disarmed with tasers.
They've been disarmed with tasers, but disarmed and shot.
No.
How many times have they actually been disarmed with tasers?
I can remember a couple times, but there were multiple officers there at that time.
And nothing happened.
Yeah, due to the fact there were multiple officers there.
You said take taser and then shot. You mean with the taser, right?
In terms of
Disarmed with the taser and shot. That was the question that you asked.
Judge, quit asking questions. It is not for you to ask these
shot with a
questions.
gun or shot with a taser, either.
Yeah, the answer is still no.
Thank you.
Judge is way too excited to get involved. She wants to make her decision now.
Yes.
And to have some fear for the device.
Yes.
And the prosecutor brought up if somebody disarms him. He said those other occasions there were other officers around.
Correct.
And is it different when the officer's on their own?
Yeah, it changes the totality of the circumstances and the reasonable fear.
I'm sorry, I'm cutting you off. But the officer has, they're trained that they can use that taser when they're by themselves.
Yes.
Okay.
Or when they're in a group,
That's all. Thank you.
you know, a bunch of men standing naked in a circle, you can use the taser then. All right, we have a jury question. I'm going to slow this down. Jury questions are always good. It lets you know what the jury's thinking.
Only if the judge could use her damn microphone.
Well, apparently all trials for this judge are bench trials because she likes to get at the facts herself.
Yeah.
I've never seen this judge before. I know nothing about her. I'm just commenting on what I'm seeing in this trial. And she asks a lot of questions that I think are the purview of the jury, and the attorney's asking the questions and not her job.
Mm.
Oh, now they're going to go silent. Yeah, the judge is acting like it's a bench trial. She does this a lot. She asks for clarification questions. At one point, we thought on day one, we thought it was a judge or a jury question, but it was a judge's question. And then she went to the jury question. And the judge's question was very involved. And I thought, like, wow, this is a good jury. And then I realized that, no, it was, in fact, a judge question. Disrobing of all female judge fund, $4.99. It's on your end, right? No, that's not mine.
No,
oh, that's
for
mine. Thanks, Brandon. We'll get there. One day we will be free of all female judges, right?
There are a few good. I mean, you have Judge, what's her name?
Oh, yeah. Come up with it on the spot, sir. Let me do some research. I'll get back to you. I'm sure I can find one. Let's speed this up. Are there a lot of jury questions, or are they just terribly confused about them?
Judge Boyd in Texas.
Yeah, she's good. She's good. So can a judge questions be ground for a mistrial? Well, the problem is that the judge would have to declare a mistrial due to her own conduct. And while I believe that would be authorized by the rules, I don't see a judge doing it.
First, would there be more energy, less energy, or the same omitted if you touch energized wires from the taser compared to having the prongs in you?
It would depend if
No, I'm
the
not. Just
insulated wire
Brandon
was
is.
intact, it would be pretty self-correcting, like touching a electrical fence on a farm. But if there was any break in that insulation, that would potentially
Yeah,
create
the
that
crowd. She was
full
good.
circuit of energy going into your body. It would, like he said, like Mr. Child said, the energy jumps through the air. It could jump through that and into the skin at that time.
And can you reload the wires, or do you have to use new cartridges on Exhibit 23?
No, we would get a new cartridge put in place. So every device is going out on the street has a brand new cartridge inside of it.
So you can't
Yeah, the judge
Cannot
Jody
reload them,
Arias,
no.
she was good.
And are officers required to take implicit bias classes or some type of mental health or psychology class, or classes in cultural competency?
When you mean class, we
Classes in cultural competency.
What?
Are the officers required to take classes in cultural competency? That was the question. At least that was the second
That's
part.
a weirdly specific question.
I think what the jury is thinking is like, well, did this officer understand the cultural norms of where this guy came from and how to read and
But
interpret
he didn't
his
know where the guy came
mannerisms?
from.
Yeah, he
That's
knew
a-
nothing about him.
That's a racist question.
But that's where the jury's head's at, or at least the one particular juror. That's kind of
Yeah.
scary, right?
Yeah.
Well, if he doesn't understand the race and the culture of the streets, then this officer is in the wrong.
have instruction on those topics, yes.
I guess would be trainings, like
Correct.
are they trained in implicit bias? So I guess I'll break it up. Are they trained in implicit bias?
Yes.
Do they also receive training regarding mental health or psychology?
Mental health, yes.
And do they receive training in cultural competency?
Yes.
And Mr. Dodge, any follow-up from either or any of those questions?
No, thank you.
Mr. Becker?
Just in terms of you watched the incident, were there any, did you see any
Yeah,
indication
Judge
anybody
Whitaker,
was
also great.
suffering from MMI or there's any reaction from the wires?
No.
Thank you.
And then we see another question from the jury, so retrieve that.
Well, we have another question from the jury. Okay. Well, that was fun. Yeah, I know. This is just one juror. Who knows? They might draw the lottery and be one of the alternates. So there's 14 jurors. Most of them are women. Most of them are white. But in Michigan, generally, again, every court could probably do it a little differently, but generally in Michigan, you don't know who the alternate jurors are until after the trial is done, after closing arguments. Then they select two and say, all right, you guys are
Does there
alternate.
have to be another point of contact, or can the wire alone deliver the effect?
No, if you were just touching one wire and the electricity is going through it, it'd be self-correcting, but it wouldn't create NMI. You need that, close the circuit with that second point of contact. You either stepping on the probe or have the drive stun going off. You need that second point of contact, if that answers the question.
Any follow-up from that, Mr. Dodge?
So one wire, let's say it's perhaps exposed wire, but if you're in contact with 2 points of exposed wire, could that create a second one?
Yes, the electricity is flowing from the device to its endpoint. So it's either the probe or if the wire is snapped in half to the end of the wire. And if you were touching that and a probe or that and the other, the end of the device, it could create NMI.
Nothing further. Your Honor.
I don't see any other hands raised on the jury. May this witness be excused, Mr. Dodge?
Yes.
Any objection?
No objection, Your Honor.
Yeah, how did
Thank you. Does taser, do you want?
how did
back?
the vampire make it onto the jury in
Yeah.
Jennifer Cumley's case? That's ridiculous. You should have
Oh, he's
seen
done.
that person coming a mile away. All right, we got another officer coming to the stand.
Jason D.
Jason Bateman.
And sir, before you speak, you can please raise your right hand. My clerk will swear to you.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated.
Thank you. Sir, can you please state your name and spell your last name for the record?
Jason Gady, last name Gady.
Sir, how are you employed?
Grand Rapids Police Department
And how long have you been
Oh yeah,
employed?
let's zoom in on the badge for a while.
since September 2000, so 24, almost 5 years.
Just going back a moment prior to joining the department, did you attend college?
Yes,
And what degree did you attain?
from Grand Valley State University, a Bachelor's of Science in Criminal Justice.
Did you ultimately attend a police
thanks,
academy?
Jude.
Yes, from Grand Valley State University Police Academy.
Now going to your career here with GRPD, can you take us through some of the different positions that you've had?
I worked a number of years night shift road patrol, and then I worked in the training unit first time as a use of force instructor and also as a departmental recruiter. And I went back and worked in a community officer capacity, and then most recently went back
That
to
would
the
be
training
my
unit
thought,
to work
Sherry.
full-time as a use of force instructor with the primary focus of coordinating the firearms training program.
And it's been a while since I looked at your resume, but do you train only within Grand Rapids Police Department? Or do you train other departments as well?
No, I'm solely a Grand Rapids Police Department instructor.
That's right. All right. And
Maybe the idea is like overwhelming force. Like they brought in 2 out-of-state experts. We're going to pull in 40 cops, all here from Grand Rapids, that are all going to say this is appropriate. Maybe it's just like overwhelming numbers. Maybe that's their idea.
Yeah, I would assume so.
I mean, I don't know why else you would do this.
No.
Hey, Jar.
as a trainer in firearms and use of force, are you well versed in GRPD policies?
Yes.
On firearms in particular?
Yes.
And your full-time duties currently are firearms training at GRPD? Is that
Yes.
right? All right, I would move to have Officer Gady admitted as an expert in the field of Grand Rapids Police Department firearms training, policies, and practices.
No objection.
I think he will be considered an expert in that field.
We've had some witnesses go over a considerable amount of time and evidence about other training policies and all those topics, but I'd just like to focus on firearms with you, if I could, and some of the training that Grand Rapids Police Department officers have on firearms. Can you give just a general overview of approximately how much firearm training an officer obtains, going back to that 8-week in-house?
For the 8-week in-house, it's pretty substantial. It's anywhere from 60 to 70 hours of live fire and firearms training, and that's not taking into account all the scenario-based training that incorporate deadly force decision-making with simunitions. On top of that, annual trainings and qualifications is anywhere from 4 to 6 times a year, several hours.
And I'm sure you could spend hours explaining every aspect of the training.
It's interesting because you have the state, the county prosecutor prosecuting a police officer, and then you have all the local cops testifying on behalf of the defense. Yeah. Usually the roles are reversed, so maybe the tactics are also being reversed. I don't know.
Yeah, and the tactics might be also a show of force against the prosecution, saying, hey, you want stuff done?
Here are the 40 officers that you're going to have a hard time with going forward.
Yeah.
But just in general, is the firearm training, is it purely shooting stationary targets, or does it also involve simulations and whatnot?
No, there's quite a bit of decision-making training built into either the live fire component and also scenario-based training.
Because reality out in the field, it's not always as simple as a stationary situation. No. Is that fair to say?
That's correct.
Are GRPD personnel trained to use various firearms?
Yes. We have different firearms platforms that we have to train and certify on every year.
Now, I'd like to move forward now to April 4, 2022, while Christopher Schurr was on patrol in the city. Did he carry a pistol?
Yes.
And as an officer within GRPD, are they required to train with a gun that they carry on the job?
Yes.
And an officer such as Officer Schurr here on road patrol,
well, we know Officer Schurr,
are they required to carry that gun on their person during their shift?
Yes.
Why is that?
in the event that they have to utilize that.
And where on their person, very law enforcement term, but where on their person is the officer required to carry the firearm?
Particularly for rope patrol assignment, on their dominant side or their strong side hip on their assigned duty belt.
As they carry that pistol, does the pistol need to be loaded with ammunition?
Yes.
Why?
So in the event that immediate response to deadly force threat is addressed, it's ready to be utilized without any hesitation.
And are police trained that they may need to draw and fire that gun as fast as possible?
With accurate, I'm sorry, yes, Your Honor. Absolutely, with an accuracy component, yes.
Can threats come quickly at an officer?
Absolutely.
Can it go from perhaps a no force, low level of force situation to deadly force pretty quickly?
Yes.
I'd like to ask you just a little bit, not about firearm deployment or use, but just weapon drawing, firearm drawing. When out in the field, and I'm not talking about training at the range, but when actually out on patrol, when are GRPD personnel trained that they should unholster and draw their pistol?
They can unholster and draw their pistol when there's a fear for safety.
Okay. And later on, does the officer then need to be able to articulate why they felt it was necessary to draw the pistol?
A lot of times it's articulated in their incident report. There is one. There's not a mandated reporting requirement, but a lot of times it does go into the incident report, yes.
And now, so it doesn't necessarily need to be a deadly force situation, just to simply draw the weapon.
Correct.
And is it fairly common that GRPD officers draw their firearms for various reasons?
Yes.
Okay. Now moving on to firearm deployment, actually firing the gun, that's different than merely drawing the gun. As far as the standards. And under policies in place back April 2022, when was an officer trained to deploy their firearm?
In response to a deadly force threat? Is that what you're?
Yes.
Yes, when there is a reasonable threat of death or serious bodily injury to the officer or another person.
And firing their gun upon someone, what level of force would that be under policy?
Deadly force.
According to the use of force training and policies, if the officer believes deadly force is necessary, what is their objective when they deploy that firearm?
To stop these subjects' actions as quickly as possible.
If it's deemed a deadly force situation, is a firearm the only way that they resort to deadly force, or can they basically use other means of force too to have deadly force?
They could use other means that would reasonably result in death or serious bodily injury to the suspect to meet that deadly force threat.
But if it's an imminent threat and the officer has a pistol, they're justified to use their pistol? Is
yes.
that correct?
It's so much better at 1.25.
Oh, yeah.
I'm sorry, sir. It's been a full morning. I'm trying not to ask you the same questions that we've already went over with some folks.
He's trying not to be communicative.
When it comes to this decision to use deadly force, use your firearm, does GRPD have policies that may lay out some of the circumstances that may be reasonable for an officer to move up to a different level of force?
Yes, it's based on reasonableness. It's based on what we say totality of the circumstances, all the circumstances present at the time the officer had to make that decision.
And is one of the circumstances that's often talked about in firearms training in particular, reaction times?
Reaction time is something that we, yes, we recognize in training, make the officers aware of, and also we try to minimize.
Now, we've already heard this topic brought up several times, but are officers warned and trained that they may be killed or injured when they don't react or act soon enough to a threat?
Yes, that's a possibility.
And in regards to firearm use of deadly force,
that's what these prosecutors
want to move on to
They
the
want
topic
people
of
to wait
targets.
until it's
Okay,
too
and
late
we're already
before
moving
they
along
make-
here, not too much to go. But if an officer decides to use their firearm against a deadly force threat, where are they trained that they may need to
Take care,
target?
Chris. Have a
Available
wonderful
target
rest
areas
of your
with
day.
the intent of stopping the suspect's actions as quickly as possible.
And not very pleasant topics, okay, to talk about, but you're a firearms trainer. Are headshots acceptable?
Yes.
And is that actually a target that's trained upon at times?
Yes.
That kind of contradicts
Is an officer
earlier
trained,
officer who said
if the officer perceives they might be in a deadly force situation, are they trained that they should fire warning shots
No,
to see if perhaps that may help their situation?
Absolutely not.
Is that allowed? If you can just elaborate, is that allowed?
No, it is not allowed or advocated.
They talked about changing their policies a little bit, but I'm not quite sure when it was changed. The most recent change to the policy that I heard testified to was in 2020, so that would have been pre-BLM. But the shooting took place in April of 2022, so post-BLM.
The officer may be in fear of serious bodily harm or injury. Are they?
I don't think it matters where on the head. Back of the head, though, does give some implications.
May alleviate the situation.
That the defense needs to overcome.
No.
Are they actually advised not to do that?
Yes, for several reasons.
But what's one of the main reasons? If you have an imminent threat and you're
trying to, again, stop the subject's actions as quickly as possible.
With recruits and officers, is it a common topic that's discussed as far as even after an individual, say if they're wounded, that the threat can still be there?
Absolutely, yes.
Just going back to some general firearms, you mentioned the officer must carry their firearm with them at all times on road patrol. Is that right?
Correct.
Moving on to the case here, you're obviously familiar with the case that we're all here on today.
Yes.
And have you had the opportunity to review the body cam, the in-dash cam, and the cell phone video from this matter?
I have.
Several times?
Yes.
Is that fair to say? Just want to talk about proximity. Does GRPD train officers on firearm use that they may need to use their firearm in close proximity to the subject?
We do, yes.
What is that sometimes referred to as?
Close quarters engagements, close quarters manipulation.
Now, if an officer, on the firearms training, okay, if an officer is in a physical struggle with a subject who's a deadly force threat, what sometimes is trained to the officer on simply backing away or disengaging from the subject?
There is times that we do train inside those close proximities to have to deploy your firearm because, first of all, they may be in a position with the subject. Either they're on the ground, pinned, tangled up in a manner that the officer cannot engage physically.
Welcome to live.
If deadly force threat presents itself, they still have to be able to meet that potentially with a handgun and be able to draw it, manipulate it, keep it in battery, and effectively utilize it, right? Another reason may be simply due to entanglement with a subject, due to physical exhaustion or physical limitations. The officer may not simply be able to quickly and effectively get up and disengage. Right? So in that scenario, again, a deadly force threat presents itself. They may have to utilize their handgun inside that close proximity. So those would be two big reasons why we train inside those close distances.
Okay. Just going to the case here, we've already exhausted several of these topics, but as you review the case here, if an officer in Officer Schurr's position is in reasonable fear of serious injury or death, was there anything inappropriate about or unreasonable about the way that Officer Schurr drew and fired his pistol?
No.
See, this is what they're going to do. They're just going to parade a bunch of cops up that are going to say that. Right or wrong, that's, I think, what they're planning on doing. If they have 40 witnesses, because otherwise I have no idea what the witnesses are going to testify to. No more questions. Go to cross. That's a good way to end. We've got like 20 minutes left.
Just in follow up to that last point, okay?
Yes.
Obviously, one aspect of this case is the fact that the bullet hit Mr. Lyoya in the back of the head. Is there anything about the fact that it was a headshot like this that's unreasonable in a deadly force situation?
Who asked about
Unreasonable?
that?
No.
That's all. Thank you.
Karen asked about that. Yeah, see, they answered your question.
Yes, sir.
Why did you refuse to meet with Detective Sergeant Julian about your testimony?
At this point, due to proximity to the case, I just didn't feel it was necessary.
He was going to ask you about what your testimony was, right? You knew that was about the case, or we want to know what you're going to testify to, right?
Yes, sir.
And you just on yourself decided it's not necessary.
Correct.
Why? How could it not be necessary? Isn't it important to have give information so people can know what you're going to say and be able to share in open court?
I guess I didn't know the full context of the meeting, or
You don't know the full context. You didn't reach out to him. You had to go through your sergeant, or excuse me, your captain, right?
that's who contacted me. Yes.
So
I guess I would object.
it goes bias, Your Honor. Why would we refuse to meet with an officer on the opposing side?
All of this in front of the jury.
Yeah.
He goes to bias, Your Honor.
I'll allow it. I'll overrule that objection.
So why, is it common practice for you just to not take it upon yourself not to meet with opposing counsel when you're called in other cases?
Haven't been contacted like that in any cases prior in any of my experience.
So the one time you are, you just say, you blow it off and say, I'm not going to do it.
Blow off was probably not the right term, but
Yeah, he comes in hot with every witness. I don't get it. He hasn't been on that long, Wim. It was the other officer that was on for like most of the morning. Oh. No, the first witness and this witness look a lot alike. That's the problem.
I wish he would answer that absolutely unfiltered truthfully. Because you're setting my guy up, you mother freaker.
Yeah. I mean, I'm still in the guilty category.
Yeah, I mean, it's that half second.
Uh-huh.
That is the and unless Schurr testifies how exactly he felt at that moment, is it beyond reasonable doubt? No, but I would understand if people are.
Yeah, at least to manslaughter. Not necessarily to second degree, at least to manslaughter, because this guy didn't ask to be put in this situation, so I don't want to see him go away for life. But I'm not supposed to take the penalty into consideration, right? Without him testifying, I'm guilty on manslaughter. That's my vote.
Let the record reflect that I'm showing the witness will be marked as People Exhibit 37 for identification purposes. Sure, you recognize that?
I get what you're saying. For me, in that situation, I would have stood up and taken 2 steps back.
What is it?
Yeah,
it appears
trained
to be
the gun on
outline
him
from the recruit class that Officer Schurr was part of.
And the recruit class, can you tell how you tell that? What are you referring to?
I see RC-1501 at the top.
And your name's on that?
Yes,
What does that indicate to you?
that I was part of the training that day.
Let the record, can I move for admission of People Exhibit 37, Your Honor?
This is why I keep saying this is the
So
perfect
now,
case to go to
part of
trial.
that was guns and vehicles, right?
Yes,
And that was the gist of this training, is how to deal with guns being in vehicles.
that's what it indicates.
in this case, you actually need a jury to determine where,
The only time I
where
would have trained-
is
Yeah,
the
we
line.
got one record of training. Have you trained him in other situations?
I would have helped out through different trainings throughout that recruit class orientation.
So are you assigned as part of the recruit class? And is that, or figure out, are you as a training officer, do different training officers get assigned to a specific class and then you're not a part of the class, or is it all the time?
There's quite a few of us, so we will plug in with certain components, trainings of that class throughout the 8 weeks.
So you plugged in for the firearms training during that class?
Some of the firearms training, yes.
Did you work with us, the defendant?
Yes. Yes.
Like, how so?
Through mandatory trainings, annual qualifications, those assigned trainings throughout the years that Officer Schurr was employed with us.
How many times since 2015 have you been involved in some sort of training?
With Officer Schurr?
Correct.
I can't throw a number on it, but there would have been a good handful.
Good handfuls at 10, is that?
Without going back on all the detailed training records, because we have hundreds of trainings throughout the year that we put, all of our sworn officers through several times a year. So
Have you worked with him then on just a day-to-day basis too?
had I worked with him, I didn't never work the road patrol assignment with him.
So just purely training?
Purely training.
Thank you.
No jury questions. That's my prediction.
So this case is from April of 2022, is that correct?
Yes.
You've been with the firearms training department since then, for the most part?
Yes, I've been a firearms instructor since then.
Over the 3 years or so, did anybody from the prosecutor's office or the detective
Here ever reach out to you or anyone else from the training department to perhaps ask for some more explanation, clarification, or any questions about this
You're not
case?
going to object the training department. We did work with the training department. So it's kind of a broad question.
I mean, I guess you could be more, I mean, if you're saying it's a broad question, you can just be specific.
Did anybody reach out to you or any of your close firearm instructors for any questions on this prior to a couple weeks ago?
I can speak for myself. The
That's
answer is
fine. That's better to do. I'm sorry.
no.
No. Okay. And you were recently reached out to, and did the defense advise you not to get back to the prosecutor or anything like that?
Nobody advised me not to. No.
Okay. Now, that sheet there, guns and vehicles.
Yes.
And I'm not sure. So maybe the point, you've known Officer Schurr on and off over the years?
I have, yes.
Is there anything about the testimony that you provided about basic firearm training and basic firearm use that was biased for Officer Schurr?
Not at all.
Okay, thank you.
None for Your Honor.
All right. Seems like we have a jury question.
Did I miss anything good?
No. Just that he claimed he is not biased and nobody told him to not go to the prosecution's investigation.
He just
And
chose.
now we have a jury question.
Oh, all right. Oh, I like the jury questions because it's giving us a little insight. Although I don't have a whole lot of hope for the defense based on them so far. Not that I really want hope for the defense. See, I'm always struggling on this case. I'm always back and forth. You got to wait until the end of the case.
Yep.
Let's see. I would submit an asinine question for every witness. They tortured me with. One of the questions was, "Can I have a bathroom break?" That was great.
So another question is, if you can clarify, when shooting or using deadly force, the target should be to stop the area of threat and to stop the subject's actions, but it's not okay to aim or target hands or arms if that is the area of threat.
Yes. So to clarify, it's not advisable, first of all, when an officer has to deploy deadly force on a suspect, particularly using a firearm. Accuracy is of great concern. Okay. So that's the other thing too. Accuracy diminishes the smaller the target area. And also, it doesn't make it any less potentially lethal. Deadly force, anything that an officer is going to deliver that would reasonably result in death, serious bodily injury to the suspect, is we don't differentiate between where it is. However, if we need to very immediately, quickly stop the subject's actions, again, hitting in an extremity may not accomplish that. If that clarifies it all, yeah.
I think you explained it well, Officer, but let's just say you have a stationary target, like a human body target. If the target were to have a pistol in the hand, raised, when you're teaching the officer where to aim, would you aim to shoot the hand or the weapon?
No, absolutely not. Again, one big reason would be the accuracy component. The likelihood of a miss would be much higher than a larger target area. So
the head is larger than the arm.
Generally aim.
And most people, some people, I feel like the arm might be larger than the head.
Again, are going to have a much greater effect on quickly stopping that the subject's actions.
And in reality, are those areas that are likely to end?
Yeah,
Yes.
I'm a little concerned.
Yes,
It is
more
a
likely.
dumb question.
It's deadly force, correct?
Yes.
Okay, thank you.
You shoot center mass, you shoot to stop the threat. And then when jurors like, oh, well, then why don't you just shoot the arm? Because the arm was the threat. No, the person was the threat. You stopped the person.
Right on the lunch hour, so what we'll do is break for lunch until 1 o'clock.
All right, lunch break.
All right, lunch.
But please leave your notes inside of your chair, you're not to discuss the case with each other. doing anything else, and also continue avoiding any news reports. in
If the
media
judge has anything to say once the jury's done.
All right, so the jury, please. Given but not asked for the witness, I would like to place them on the record. The first is, do we know if Mr. Lyoya was left-handed or right-handed? And so, because that particular witness wouldn't have had knowledge about that question was not asked. And the next was, can a series of least optimal, though possibly reasonable choices ultimately result in choices that are unreasonable, given, I can't read that word, given some kind of events or an unreasonable situation in relation to your review of this or any case? First, that's a pretty open, broad question. Second, it's up to the jury to decide what's reasonable, what's not reasonable. And obviously, any review of a different case wouldn't be relevant to this case. I don't know if there's any other objectionable language within the question that you would like me to place on record, Mr. Dodge.
I thought the first question was reasonable, but agree with the judge that it probably wasn't the best witness.
And then just to place on the record, because there were two questions asked up this last time, but one just said this question to me about some court procedures and language that's used. And so I intend to respond. One is asking how come some people ask to approach and some don't. And then another is remind what sustain, overrule, and other terms that I say mean. I intend to just write a note back saying, as far as how come some ask to approach and some don't, you should not be concerned with focusing on this exclamation point, because I don't want them focusing on, wait a minute, why didn't they? So that's my response to that question. And then sustain, I was just gonna write court agrees, overrule means court disagrees. And then I don't know what other terms are referring to. Is that an okay way? I don't want to not respond to the question because it was asked. And I also don't want to respond in a way that's not okay with both sides. Mr. Becker?
No problem, Your Honor. That's fine.
Okay, so I'll just pass it back. Okay, and is there anything else we need to address before we break for the lunch hour?
No, Your Honor. Nothing much, Your Honor.
Okay. So we'll be recess for lunch until 1 o'clock.
All right, there we go. So we are in recess until 1 o'clock, which is about 15 minutes from now. But Nick and I are going to shut down this stream and redirect to an afternoon stream.
Yep. Which will be start 4 p.m. That
4
way
p.m.
we can speed through a bit more. I mean,
That's
playing in
crazy.
1.25 or even 1.5 to get through all of this. But
It's-
if you want anything to watch in between, I just posted Judge Simpson's morning docket.
Oh, okay.
And, yeah.
Just
And it's a criminal docket, and it's a lot of cases. And he is as good as he usually is.
They do need to call a use of force expert, I think.
Yeah.
Although I think they're going to rely on the local cops. I don't know how well that's going to be, but I can't watch this droning direct examination at real time. It's mind numbing. So we're going to come back at 4 o'clock. So that's in about 3 hours.
Yeah.
And then we'll be able to watch it on 1.25 or 1.5 speed, depending, and we'll go from there.
Yeah.
Yeah, I'm still on the fence. I'm not sure how this is going to shake out.
Yeah.
Yeah, but you guys, that guy is amazingly. Yeah, I don't think so. Zach is just popping in at the end. All right. Thank you all for joining us. Go check out Nick's video he just posted with Judge Simpson, and then come back and join us in a few hours. See you guys then with Prosecco, I guess. Yeah.
Okay, see ya.
Two screens light up justice calling from sweet and cold and Great Lakes falling. Educating fools, real talk streaming. Truth and laughter, crime redeeming. humor through the tears. Bang the gavel, crack the screen, courtroom chaos in between. Wine and laughter, we all bleed. Streaming trials, feeding need. Layers of law, peeling truth bare. Last for a while, do we even care? Chip on shoulder, beer in hand again. Together on this shaky stand. Raise your glass to law and jest. Trials not just pain and stress. Teach the world, grind the gears through the humor, through